Order to make a mention. Lordships were pleased to direct calling for the antecedent and so also the custodial certificate from the authorities and directed matter to be listed for orders on 10th March regarding bail in a criminal appeal. Yours.
10th is today. It has not been given. Part of the mention, Lord, one appeal, writ appeal matter of 2018. Readings have been completed. Lord, can you please say
land acquisition matter, Lordship, I am the opposite party number. And government has declared as land acquisition.
Matter relating to allotment of Joban lease land.
The wife of opposite party, wife of the petitioner was illegally detained by the opposite party number 5. The
WPCRL matter.
That's
Pardon to mention here, this is a PIL matter. It's in front of the boundary wall of Modification Law University, in the second campus. The vending zone is
If the memo, it will come before the Honorable Chief Justice. There is no such urgency. It will come on.
My Lord, writ appeal matter 2018.
June.
Lordship, this is a writ petition against the order passed by the learned tribunal, Your Lordship. Matter was specifically adjourned to 17-2. Supplementary list. Item number 1.
On behalf of Mr. P.K. for us to be family.
Have you supplied the legible copy of
other day? At Annexer 7, that legible copy. I have now also file for this. Copy.
Give a copy to him. Yeah. You are seeking for adjournment for how many weeks? 1 week or more?
3 weeks time.
3 weeks.
Even the legible copy that you have supplied to the court is not legible so far. Page 36 is not at all legible.
Part of the
Annexure 7. Type कर दी दलेनी.
Legible means you have to give it in type copy.
गुड़ाको आमे पढ़ी परिबुनी ताकू देले कौन? You give a type copy. We are mentioning it that type copy. Legible. We are mentioning type copy. है ये तादर पुनी आउथर जेरोस कर दे से clear होगा. बुझले? लेखो. Do the learned counsel for the petitioner has filed legible copy of Annexure 7, but on perusal of the same, it appears that it is also not legible. Let the learned counsel for the petitioner files a type copy, true copy of the order under Annexure 7, and supply a copy of the same to the learned counsel for the state. Learned counsel for the petitioner seeks for an adjournment for 3 weeks. Matter to be listed. 12 May 2020.
Item 2.
The matter when I am assembling the criminal order. The last order, the similar matter which has been pending before the Appeals Court. I will send along with affidavit.
Just a minute. 6325 order you got.
6325.
One from appealing from the opposition to produce the order dated from which has been filed challenging the judgment and order of this case. Also the order of challenging the judgment of the court and both the matter in order has been passed and the operation of the order has been sweet. Just produce the same affidavit of this line. Function upon account of appearing on behalf of the Indian 6 and item to apply this court over the status of the USLP which are subjudice before this court. That was
Still pending, man, not listed for the hearing.
Mr. Vishwajit Maharana, learning senior panel counsel. Senior panel counsel appearing for the Union of India submits that the to specially petitions which are being filed by the Union of India before the Honorable Supreme Court has not yet been lifted, and therefore this matter may be adjourned for 4 weeks. This matter, summer vacation for a proceeding. Yes. Honorable.
Item 3.
Please note, after Annex 2 of the retribution, in all the cases, the recorded tenants' legal acts have been substituted. Now, petitioner before my lord. Only I remind the para 2, after para 2, para 3 has to be substituted in the amendment.
IN number so and so for amendment.
This
So that is
family
specified as-
genealogy.
Generally, I have specified all the petitioners before my lord. As per Annex 2, recorded tenants are there. Some many persons have died.
So Behra prayer portion ପରେ ଗୋଟେ schedule ହୁଏ ଏବଂ କୁହାଯାଏ ଯେ ଏଇ schedule ଟାକୁ incorporate କରାଯାଉ। ଆପଣ ତ schedule କରିନାହାନ୍ତି ଯେ
Schedule କରିଛି।
petition ଭିତରେ କୋଉଠି ଲେଖି ଦେଇଛନ୍ତି?
Schedule କରିଛି just ଖାତା number so and so.
ଆପଣ ଆସିଲେ prayer portion ପରେ କୋଉଠି schedule ହୋଇଛି?
Proposed amendment ର ଗୋଟେ schedule ହବ ନା?
ଯୋଉ proposed amendment ହବ ତାର ଗୋଟେ schedule ହବ। ତେଣୁ court order pass କରିବ this will now form a part of the so and so। ତାପରେ ଆପଣ consolidated petition ଦେବେ।
Proposed amendment.
It is only an averment.
schedule ରେ ନାହିଁ।
ଖାଲି ମୁଁ ଦେଇଛି
ଆପଣ ଲେଖିଛନ୍ତି ଯେ allow the IA and will be pleased to allow the amendment sought for specified in the schedule. Where is that
No,
schedule?
schedule
is not there.
schedule I have not written, but
अरे ଆପଣଙ୍କ prayer ହଉଛି schedule ଟାକୁ incorporate କରାଯାଉ। schedule ହିଁ ନାହିଁ ତାହେଲେ ଆମେ incorporate କଣ କରିବୁ? ତେଣୁ you withdraw this interim application, file a better one.
What is required in an amendment petition is, as you know, proposed amendment schedule. That's all.
I just
No, it's only in the body that we can. How can we?
The interim application has been filed IN number so and so for amendment of the writ petition. Though in the prayer portion it is mentioned to allow the amendment sought for specified in the schedule, but there is no schedule of the proposed amendment. Therefore, the land council for the petitioners seeks permission to withdraw this interim application and to file a better interim application. Put up this matter on such and such date. In the meantime, if any interim application for amendment is filed, the same shall be placed on record. Yes, same order in other interim applications under item number 3. Yes.
Item 4. May I please, Your Lordship?
That's fine.
Your Lordship, may kindly tell us the last order, Your Lordship, 17/2025 election. Direction was given to the opposite parties to obtain instruction, Your Lordship, regarding the status of the proceeding pending. Your Lordship.
Have you gone through the order dated 17/2/2025?
I've gone through also, letter has been issued.
So, कौन करिया?
They have Tahsildar Sadar though, but it is not adequate, that information. They have given on 7th March, but this is not adequate.
Deputy collector address कले सब collector को, है ना?
ଆଜ୍ଞା
ଯେ no lease deed has been attached to the Khasmat
ଆଜ୍ଞା
case record. ସେଥିପାଇଁ ସେ ଲେଟର ପାଇଲା ପରେ ସବ୍ କଲେକ୍ଟର କଣ କଲେ ନା ତହସିଲଦାରକୁ ଲେଖିଦେଲେ। ତ ଏଇ ଟାଇପ ର ଅବସ୍ଥାରେ ସେଟା ପେଣ୍ଡିଂ ହେଇକି ରହିଛି।
ଖାସମାଲ ଲିଷ୍ଟ
ତେଣୁ ହଁ ତେଣୁ କଣ ତାର ଡେଭଲପମେଣ୍ଟ ବିଷୟରେ ଆମେ ହେଲା ଜାଣିବାକୁ ଚାହୁଁଥିଲୁ। Annexure 3 ଯୋଉ ଲେଟରଟା ଇସ୍ୟୁ କରିଥିଲେ। ତ you have received some instruction but
but it is not adequate, my lord. It will not suffice the query, my lord. I need
so we are granting you some further
Aye.
time. The learned counsel for the ତା ସାଙ୍ଗରେ କଥା ହେଇଯାଆନ୍ତୁ ଯେ କଣ
ମୁଁ direct
instruction ଦେଇଛନ୍ତି ନା।
କଟକ
The learned counsel for the state submits that even though as per the order dated 17/2/2025, he has received instruction. କାହାଠୁ instruction ପାଇଛନ୍ତି?
This is Tahsildar Sadar.
From Tahsildar Sadar Cutter. But that is not clear and adequate, and therefore he wants further instruction in the matter, and the matter may be taken up प्रत्येक ଗୋଟେ ଦି ସପ୍ତାହ ପରେ ଆଣିବା 2 weeks after. तो 5 तारीख रे नहीं आसु
ଆଜ୍ଞା
5th of May 2020
ଗୁଡେ ରହିଗଲାଣି 6 କି 7
अच्छा
ବହୁତ କାଲି
7th May
ଆଜ୍ଞା exactly
7th May
Item 5.
Petition study displays property legal irrigation project. For their rehabilitation and resettlement, opposite parties have provided 14 to 15 decimals of residual lands instead of 20 decimals of land. But thereafter, and it's a annexure 3 series, they have
No.
provided
where is the documents that your land has been acquired? First of all,
annexure 2 series,
annexure 2 series.
identity cards have been issued as you the displaced family.
Take care of.
The similar matters have been
Wait,
discussed.
similar matter. अरे ठीक है रुहନ୍ତୁ ଆମେ ଗୋଟେ we are verifying a document. So why so many persons have filed this writ petition?
Same village, same issue.
No, same issue କଣ କର ଖାତା ନମ୍ବର ଇଏ ନମ୍ବର ଏଗୁଡାକ ସବୁ ଅଲଗା ଅଲଗା ହେଇଥିବ
compensation ଏକା
compensation amount
area ଏକା
କେମିତି ସବୁ ଅଲଗା ହେଇଥିବ ନା ତାର ଲ୍ୟାଣ୍ଡ ଯେତିକି କାର compensation ଅଲଗା ତାଙ୍କୁ ସମସ୍ତଙ୍କୁ କ୍ଲବ ଅପ୍ କରିଦେଲେ
ସେଟା ଯୋଉ ଆଇଡେଣ୍ଟି କାର୍ଡ ଟା ସେମାନେ ଦେଲେ ସେମାନେ ଆଇଡେଣ୍ଟି କାର୍ଡ ଅନୁସାରେ ସମସ୍ତେ
ପବ୍ଲିକ ଇଣ୍ଟରେଷ୍ଟ ଲିଟିଗେସନ ନା କଣ ଇଣ୍ଡିଭିଜୁଆଲ କେସ ରେ ଆପଣ ଯୋଉ କ୍ଲେମ ରିଲିଫ କରୁଛନ୍ତି ତା ଦେହରୁ ହୁଏତ କାହାକୁ ସେମାନେ ଦେଇପାରନ୍ତି ଯୋଉ ସ୍କିମ ରେ କାହାକୁ ନ ଦେଇ ପାରନ୍ତି ଇଣ୍ଡିଭିଜୁଆଲ କେସ ବେସିସ ରେ ସେଟା ଆଡଜୁଡିକେଟ ହବ ନା
କେମିତି ସେ ଦେଇଛନ୍ତି ଏ ଆଇଡେଣ୍ଟି କାର୍ଡ ସେଥିପାଇଁ ତାଙ୍କୁ issue
no this ROR annexure 1 is in belong to whom? All the people, all these petitioners.
No, ma'am.
Then so you are citing one ROR and expecting the order for all. How could it be?
you file individual cases not in this
similar matters have been disclosed.
no କଣ ହେଇଥିବ ଅଲଗା
Then
the same village, same issue.
we don't know.
This writ petition has been filed by the petitioners with a prayer for a direction to the opposite parties to provide the rehabilitation and resettlement benefits to the petitioners as per present market value by following the norms of Odisha Resettlement and Rehabilitation of Project Affected Persons Policy 1994. It appears that not only the land particulars of each of the petitioners are different, but the compensation amount which has been paid is also different. And a series of documents have been annexed under Annexure 1 series relating to the record of rights. we are of the view that the writ petition should be filed by the petitioner separately and highlighting the um, documents the available with them. They are land particulars, the amount of compensation that has been received, etc. And stop. At this stage, land counsel for the petitioners seek permission to withdraw the writ petition with giving for liberty, seeking for liberty to file the writ petition by individual petitioners according to the petition is disposed of. Yes.
One line.
Next.
Item 6.
My lord, sorry. The lead person filed over the petitioner seeking a direction to the Tahsildar Boramba to consider his lease application. Lease application is Annexure 1.
Annexure 1 which 14/2/94
No, you made a application for lease of land in proper application.
Proper application.
Then what happened?
Tahsildar does not listen.
No, listen
When did you?
94 ରେ ଫାଇଲ କରିଥିଲେ Annexure 1 ରେ କେତେ ବର୍ଷ ହେଲା
24 ରେ ଦେବେ।
94 ତ 30 ବର୍ଷ ହେଇଗଲାଣି 30 ବର୍ଷ ଧରି କଣ କହୁଥିଲେ କିଛି ମାନେ
What it is instructed by the petitioner? Every year, she is approaching the Tahsildar orally.
And was also sitting before the Tahsildar in the Tahsil office every year. Till 30 years.
ଧାରଣାରେ ବସିନି କିନ୍ତୁ ସେ ରିକ୍ୱେଷ୍ଟ କରୁଛି ଆଉ
What do you expect this court?
ମସିହାର କେସଟାକୁ ଆମେ
ସେ କଲେକ୍ଟରଙ୍କୁ ବି ସାର୍ Annexure 2 is the grievance
we
petition.
do not know that that might have been disposed of and adverse order might have been passed. Who knows?
No, my lord, no dispose.
Once such an application is made and if the date is correct, then a number is allotted and a copy is also provided to the applicant. This particular document which you have filed under Annexure 1 does not show that this has been accepted by the concerned authority. There is no endorsement here. Form 1 ରେ କିଛି endorsement ଅଛି ତାଙ୍କୁ ଦେଇଥିଲେ ବୋଲି
ନା
ତାହେଲେ
କିଛି ନାହିଁ endorsement ନାହିଁ କିଛି
14/2/94 ରେ ଆପଣ ତାଙ୍କୁ କେମିତି ଦେଲେ ପୋଷ୍ଟାଲରେ ପଠେଇଲେ ନା ନେଇକିନି ବ୍ୟକ୍ତିଗତ ଭାବରେ ଦେଲେ କେମିତି ଦେଲେ ବ୍ୟକ୍ତିଗତ ଭାବରେ ଦେଲେ ସିଏ ନିଶ୍ଚୟ ଗୋଟେ ରିସିଭ କରିଥିବେ ତାଙ୍କର ଗୋଟେ ଏଣ୍ଟ୍ରି କରନ୍ତି ଏବଂ ଗୋଟେ ଆପଣଙ୍କୁ ଗୋଟେ କପିରେ ସିଲ୍ ମାରିକିନି ଦିଅନ୍ତି
My lord, it is the fact that the original application remains with the Tahsildar. It is the copy of the
copy of fundamental dose ଆମେ କେମିତି how the court will be satisfied then on 14/2/1994 this petitioner submitted the application. Except your averment, is there any documentary proof?
Your lordship may dispose of this matter directing to make a fresh application.
Directing କଣ ଦରକାର ଆପଣ ତ ଫାଇଲ କରିବେ ଯଦି ଆପଣ ଏପର୍ଯ୍ୟନ୍ତ ଜମି ପାଇନାହାନ୍ତି ବା ଆଡଭର୍ସ ଅର୍ଡର କିଛି ହେଇନାହାନ୍ତି ତାହେଲେ ଆପଣ ଆଉ ଗୋଟେ ଆପ୍ଲିକେସନ ଦେବେ ଡାଇରେକ୍ସନ କଣ ଦରକାର?
Even you are not saying that a lease miscase has been initiated on the basis of your Form 1. How can we
initiated?
Where is that number?
Where is that number?
ନମ୍ବର ସେ କଣ ଆମର ସେ ଗରିବ ଲୋକ
କଥା ଲିଜ ମିସକେସ ନମ୍ବର ରେ ପାଇବାକୁ ଗରିବ ଇଏ ଦରକାର
ସେ ନମ୍ବରଟା ସେ
they are public servants they are supposed to duty ଲେଖନ୍ତୁ this writ petition Modamba opposite party number 3 to issue lease quota in favor of the petitioner with the proposed area Corsun 28 decimal The plot number 4260, khata number 842 of Mauja, Koradi Bandha.
Oh, a specific land is to be leased in your favor.
Selection pura kar deji. The Land and Counsel for the petitioner has filed the lease application as Annexure 1, which is dated 14 to 1994. There is no endorsement in this application that the author has received such application, and there is no averment that after receipt of this application, whether any lease miscase has been registered or not. There is inordinate delay of more than 30 years in approaching this court. Therefore, we are not inclined to entertain this petition, which is accordingly dismissed. Yes.
My lord, liberty may be
Liberty
granted
ଦରକାର ନାହିଁ, ଆପଣଙ୍କର ଅଧିକାର ଅଛି, ଆପଣ ଯିବେ ଆଉ।
my lord, he may be evicted by the Tahsildar.
ଓହୋ ଏଟା ସେଇଥିପାଇଁ ଦେଇଥିଲେ ଏଟା
My lord,
ହଁ ଠିକ ଅଛି ନେକ୍ସଟ
my lord,
Item 7.
7
This is liberty to withdraw the application and to file affidavit on this.
ଆପଣ ମେମୋଟି ଦଉଛନ୍ତି ନା
And this is the similar order.
withdraw କରିଥିଲେ ତା ଦେହରେ the 3G5 provision and controversial permission I will do the decision. The order the change over the prayer portion the change. How could a metal phone?
Item 11.
11.
Same order in item number 11. Yes. हाँ दे दियंतु स्लीप रे दे दियंतु एटा मध्य यूनियन ऑफ इंडिया रछि आइटम नंबर 7 7 ने कहा ना रहिबो
राजगुरु जे
दे दियंतु 7 ने कहा ना रहिबो आ 11 ने कहा ना रहिबो हां स्टेट रिप्रेजेंट नहीं यूनियन ऑफ इंडिया तरफु कहा ना रहिबो लेकिन से माने लिस्ट दो ना दी
हां दो
यानी यूनियन ऑफ इंडिया
Union of India.
those A list they give you a list.
Item 8.
Yes,
in this case, I challenge the order passed by the 18th Suvarnapur. Similar matter has been dismissed
Yesterday.
by Lordship on 8/4/2025 in respect of the son. He is the father.
कौन है काली काली लिस्ट इतला
No, dismiss is
Dismiss is ଗୋଟେ alternative remedy ଅଛି ବୋଲି କି ଗୋଟେ କରି ଆଉ ଗୋଟେ ସେ
ତାର ଗୋଟେ କପି ଦଉନା କି ସେଇ ଅର୍ଡର ତ
Order the Bahari.
କାଲି ଆଇଟମ କାଲି ଥିଲା
All the
WBC 8292.
ଦିନ ମାନେ ସୋମବାର ଦିନ ଲିଷ୍ଟ ର କେତେ ନମ୍ବର ଆଇଟମ
19. Item 19.
ସବୁ ତ ସର୍ଟ
ଅର୍ଡନତ ହେଇଯିବା କଥା
अरे से लिस्ट देखिलो आइटम ठीक है मैं देखी दो वेरीफाइड अपलोड तो सब और देखिलो संध्या रे जस्ट प्लीज सोमवार कॉज लिस्ट बाहर करंतु आइटम नंबर 19 को 1900
Millers.
मार तो डब्ल्यूपीसी यस नंबर नंबर तो दिलो कि तुम
दे
अरुण नायक
Millers.
मैं अपलोड है नहीं सेटा देखि
after dispose of
हां डिस्पोज ऑफ देखि ऑर्डर टा अपलोड
order କେମିତି
ये टिके तळु खला नहीं डिस्पोज कर ले कि ऑर्डर टा अपलोड आ की डिक्टेशन नहीं टिके देखो हला सोमवार दिन आइटम नंबर
19.
ऑर्डर को इमीडिएटली अपलोड कर दे ये तुमको କହିଥିଲି ମଝିରେ ମଝିରେ ଚେକ୍ କରିବୁ randomly ହେଲା ସୋମବାର ଦିନ ଲିଷ୍ଟର ହେଲା ଏବଂ ତାପରେ ମଧ୍ୟ randomly ଚେକ୍ କରିବୁ ଯେତିକି ମ୍ୟାଟର ଡିସ୍ପୋଜ ହଉଛି ବା ଅର୍ଡର ହଉଛି ଦେଖିବୁ ଅପଲୋଡ ହେଲା କି ଗୋଟେ ଦିନ ପରେ ଚେକ୍ କରିବ ହେଲା
No, no. In our bench, we are ensuring that it should come on the very day.
ହେଲା
We are trying our best.
ଆମେ ସନ୍ଧ୍ୟା ସୁଦ୍ଧା ଆମେ ଅପଲୋଡ ହବାକୁ ଚେଷ୍ଟା କାହିଁକି ସେଇଥିପାଇଁ ଦେଖିଦବୁ so same order will be passed same order to be passed yes. item number 19 Monday list खाली लिखी जाए है ना नंबर टा दीजिए WPC
3292
3292
of 2025.
2025 कौन order टा इसला टी पहले
So it's a dismissal or dismissal on the
Dismiss
ground
it,
of delay and lapses.
अच्छा
Brilliant.
अच्छा ठीक है
ଆଦେରେ ଖାଲି ଗୋଟେ WPC ଟା ଯୋଉ ଅର୍ଡରଟା ହାଇକୋର୍ଟ ଦେଇଥିଲେ ସେଇଟା ଖାଲି ଚେଞ୍ଜ ହବ
Ah,
ଆନେକ୍ସ 6
right.
ତା ନମ୍ବରଟା ଆଉ ଡେଟଟା
ठीक है
ଆଉ
yes
ସବୁ ସେମ୍
आज आइटम नंबर 8 और हाई कोर्ट ऑर्डर टा चेंज हो पूछंती
And
सेटा
6.
हां नेक्स्ट सेटा उठे देखि लेते ये
Item 9.
पासवर्ड करो के नाम थी
Item 10.
The opposite party has filed a caveat application. I'm sorting a copy just now. My
35 कॉपी काई डिस्पेंस हुई थबो
copy.
कोन असुविधा लगी
may I pay 7 days? I have already applied.
हां ठीक है IA number 742 of 2025 is an application for exemption to file the certified copy of the impugned order dated 10/4/2024 passed in OA number 158/2019. Mr. Disciplinary Bhokta, Learning Senior Parent Council, Central Government Council, submits that certified copy has been applied for and the matter may be taken up a week after in order to enable him to file the certified copy. Please this matter so and so. It IRA pass with after WPC Mr. Bhokta handed over the copy of the writ petition to Mr. Dilip Kumar Mahanti, Learning Counsel, for the opposite party who has filed the caveat petition number 2818 of 2025 in court. He seeks some time to go through this and put up this matter on गोटे सप्ताह पर 5 तारीख रखिए ना 5th of May 2025 ठीक है
Item 12.
Under section 54, Humble stating by the Honorable Court, Honorable Court grant a permission to file a better applications by the opposite party number 2 and opposite party number 2 consider my application within the time limit. Similar type of order earlier already ordered passed.
कौन देखिए
Earlier 2 orders.
ଏତେ ଗୁଡା କଣ ଦଉଛନ୍ତି ଗୋଟେ ଅର୍ଡର ଦିଅନ୍ତୁ
ଆଜ୍ଞା ଗୋଟେ ଆଉ ଗୋଟେ
ଆଚ୍ଛା ଦିଅନ୍ତୁ ଦିଟା ସେଟ୍
ଆଜ୍ଞା ଆଜ୍ଞା ଆଗରୁ ହେଇଥିଲା
Today, this is the only matter.
ଆଜ୍ଞା ଗୋଟେ ହେଇଥିଲା
seeks permission to withdraw the applicant to file a better appeal before the accredited person.
ये repentation न देगी
এইটা পুনি কোন এইটা যে সেকেন্ডটা দিয়েছেন কোন
conditions like filing better than considered by the opposite party now within the time.
application file কলে সিনা কনসিডার করিবে
আজ্ঞা আজ্ঞা
এই ফার্স্ট ব্যাপারটা লিখছি এটা দেখতে দিন
Why to give liberty? You have a statutory right for this.
We have already received this.
No issue.
File. This follow. Yes.
Item 13.
Also, in item number 13, the petitioner is working in District Court, Nayagढ़, Your Lordship. Based on a disciplinary proceeding was initiated, and Your Lordship was a member of the committee. Annexure 6, Your Lordship.
Is it? All right.
I took it. So
Madam want to see me out, so I'll.
not in that way. Yes, fairly stated. Learn put up this matter before some other bench in which one of us, Honorable Justice CHITTARANJAN Das is not. Yes, next.
Item 14.
For next week, man.
All right.
Let us save and select.
You are asking for 1 week time.
Minor.
All right. One counsel for the petition, 6 for an adjournment for 1 week. So, 21 तारीख रखिएगा, हाँ, ठीक है. 21/4/2025. Yes.
Item 15.
Earlier, this case was listed, Your Lordship has passed an order for maintainability. This is a case arising out of order of the collector arbitrator.
Mr. Counsel, have you, London State Council,
This one,
have you gone through the order dated 23/2025?
Annexure 7.
No, I'm order. କି ପଢିଲେ କଣ ଆଉ ଆଗକୁ ପଢିବେ ନା ଆଉ ଅଧିକା ପଢିଲେ କଣ ମେଣ୍ଟେନେବିଲିଟି ଆଡ୍ରେସ କରିବେ ଅର୍ଡରଟାକୁ ପଢନ୍ତୁ କାଲିକି ରଖିବା ନା ପହରଦିନ ଏଇ ଯୋଉ ନେକ୍ସଟ ୱିକରେ ରଖିବା
Next week. Alternative remainder. Alternative remainder aspect. See, he has raised that 3G.
ଟୋଟାଲି ପଢି ନାହାନ୍ତି ତ ମୁଁ ସେଇଥିପାଇଁ କହୁଛି let him be satisfied, let him go through the order. 16 ତାରିଖ ନେଇ ଆସିବା. Hard Mr. S. Nandi and counsel for the petition and counsel for the state.
16 तारीख शुक्रवार.
नहीं 16 तारीख No, it's all right. So, submit that he wants to go through the order dated 23/2025 and address the court with this matter commencing from 16th April 2025. Yes.
Item 16.
16.
Item 16.
16 तारीख को.
Item 16 had the Lordship, it is a matter whether petitioners were engaged and working as a casual employee. So basically, Your Lordship, or in Annexure 2, there is an office memorandum where Your Lordship, which was clearly, it was by the Government of India, Ministry of Finance, which clearly states that they cannot engage the labor in casual.
You are challenging the
order at Annexure 1, Your Lordship.
Annexure.
Your Lordship. Your Lordship, may bring Your
Who is
Lordship.
appearing for you? So, please come to Annexure 1 and please say that what is the...
Your Lordship, Annexure 1, Your Lordship, at page number 18. So that will bring Your Lordship to page number 18.
What was your prayer before the...
Your Lordship.
Come to paragraph number 1.
Your Lordship.
Page number 16.
Your Lordship. Your Lordship, the prayer was, because I have already annexed the OA, which is at annexation 9, Your Lordship.
Annexation 9.
Your
ठीक ଅଛି।
Your Lordship, may I just submit on to you? Your Lordship, it is a matter.
अरे ଟିକେ ବ୍ୟସ୍ତ କାଇଁ ହଉଛନ୍ତି?
Sorry.
ଆମେ ତ ବ୍ୟସ୍ତ ହଉନୁ, ଆପଣ କାଇଁ ବ୍ୟସ୍ତ ହଉଛନ୍ତି? ହଁ ଆମେ ପଚାରୁଛୁ ଆପଣଙ୍କ ପ୍ରେୟାର ଟା କଣ
Your Lordship.
ଦେଖେଇବେ।
What was the prayer before the tribunal?
Your Lordship, the prayer before the tribunal is at page 63, Your Lordship. Annexation 9.
Okay, so that relevant page is 63.
Your Lordship.
Relief sought was the letter dated 16/1/2025 issued by respondent number 1 terminating the engagement of casual laborers at annexure 1. The respondent to continue the services of the applicants with pay admissible to them and pass such order. How many persons were the applicants before the tribunal?
Your Lordship, 4 petitioners. 4
Okay,
applicants.
there are 4 applicants.
Your Lordship.
And this writ petition has been filed by all of them.
Your Lordship.
Okay, so come to the now the impugned order.
Your Lordship, the impugned order is at annexure 1.
Achha.
Your Lordship,
So you skip over the, come to the paragraph number 4.
Your Lordship. Your Lordship. Paragraph. May I place it, Your Lordship?
Place it, place it.
Your Lordship. Your Lordship, after considering the submission of parties, this bench sought clarification from the learned counsel for the applicants as to whether the applicants have been thrown out of their engagement in pursuance of the letter dated 16/1/25. Learned counsel for the applicants has fairly submitted that the services of the applicants have not been terminated but are likely to be terminated detrimental to their interest. We find that the order dated 16/1/2025 has been issued as a matter of policy to all the head offices of Odisha region directing termination of engagement of daily wages public casual workers engaged after imposition of ban on engagement of casual worker by office memorandum DOF number such and such dated oblique 10/12/2008. But here the operative part is the applicants did not challenge the office memorandum dated 4/10/12/2008, which is the root of the letter dated 16/1/2025. The letter dated 16/1/2025 has been issued to all the concerned, which the applicants have sought to quash in this OA without giving details relating to others whose case might not be similar to the applicants. Further, the applicants did not produce any such document evidencing that any such action has been taken pursuant to the letter dated 16/1/2025 adversely affecting their interest at this stage.
They have also approached this tribunal without availing.
Approaching without availing of opportunity available to them by way of making representation, which is also a precondition provided under Section 20 of the Administrative Tribunal Act.
So, what is the illegality in the order?
Your Lordship, the illegality in this order is, Your Lordship, the OA was never entertained basing on just one ground, 2 grounds, which is reflected here. One is that as there has been not a single ground taken challenging the office memorandum dated 10/12/2008. Your Lordship. Your Lordship.
That is on the ground 1 is delay.
Your Lordship.
Number 2.
Precondition has not been.
Precondition that is not satisfied.
Your Lordship.
And number 3, that in spite of that fact that the order was passed on 16/1/2025, you have not been thrown out of the. So
No,
that is the.
It has not adversely affected you by any action of the authority. So which action is to be challenged?
Your Lordship, here, Your Lordship, the submission is, Your Lordship, here the OA got dismissed on this particular ground. Whereas, Your Lordship, the conducting counsel before the Central Administrative Tribunal could very well take liberty to file a better application.
Where?
Before the Central Administrative, by withdrawing and by taking a liberty. Your Lordship, no liberty is granted. Because the basic on a bare reading, because Your Lordship, the
No, don't go to that. That is not in order.
Your Lordship.
If you
No,
say,
that is not Your Lordship. That is why I have approached this honorable court.
suppose you say
Your Lordship.
that during course of argument,
Your Lordship.
the learned counsel appearing for the petitioners in the original application made a submission that I seek permission to withdraw this original application.
Your Lordship.
Right?
Your Lordship.
But somehow or other, the court has kept it and subsequently passed this order.
Your Lordship.
So he remained under an impression that this will be withdrawn and I will be given liberty to file a better original application with better particulars. So if such an order has been passed, then the first thing you are required to do to bring it to the notice of that very court which passed the order. Sir, on such and such date, I made this prayer. I have not argued the matter. I said, withdraw this matter. So when the matter would be of the court, he can recall that order and pass an order to permitting you to withdraw the writ petition. So that is the law. So if you say that something has been wrongly mentioned in the order, and so the recourse is to approach the same court with a relief. Are you aware about the decision in that light? So the 82 Supreme Court is there. Find out that decision. So many other decisions are there. When the matter is still fresh in the mind of the court, you have to approach the very court and apprise them that this is the thing I have raised and this has not been taken note of it, or it has been wrongly recorded. This is not my submission. The court can pass appropriate orders.
The conducting counsel before the central level was a different counsel.
But
have you taken any ground here in this writ petition that the mention was made to withdraw the original application? Then how can you?
Your Lordship, mention was never made, Your Lordship.
You are making a submission that during course of hearing a mention was made by the counsel who is appearing before the Central Administrative Tribunal to withdraw the.
Your Lordship, if there would have been a liberty, mention would have been made that to withdraw this original application and to file a better application, then Your Lordship, I would have the right to direct you to file before the Honorable CAT. But as Your Lordship, no liberty has been sought, and the employees who have been placed in a similar footing and their original applications have been entertained, admitted, and notices have been issued.
Yes.
So, my lords, if right now, if I go and file another fresh original application, so, my lords, it may be barred by a res judicata.
No,
So
not
Lordship, I'm just saying that a liberty may
that
be
cannot
granted.
be done.
Tribunal, Lordship kindly have a glance to page 18, the informed order. The tribunal has categorically held that this petition is premature. So, it is open to him to file.
In one way, it is premature. The other way, the original of this has not been challenged. Now, this is a consequence of that. So, if the original is not challenged, how can you do this?
That was the thing where the council was conducting. He could have taken the liberty to file a better.
So, how can you do this right now?
Your Lordship, because the similarly placed employees, their cases have been.
We do not know whether the similar employee or not.
Your Lordship,
it could have been brought to the notice of the learned presiding officer that similar matters have been, notice has been issued, and this is the order. Matter would have been ended there. But you argued the matter and did not produce that order in which notice has been issued. Now you are saying this would have been done by the council. He has not done it. He could have withdrawn it to file the better application. What you could have done there, if you have not done, what can be done?
Your Lordship, I'm just praying because Your Lordship, before the lower forum,
we have to see on the face of it whether the order is there is any illegal or there is anything to interfere with or not.
Your Lordship,
we find that the order has been passed correctly.
Your Lordship, because if Your Lordship kind of a glance of these two orders, I can show you because Your Lordship.
No.
We are not in appeal, sir.
Your Lordship, I'm just praying that
what has been passed in other case, unless it is brought to the notice of the very court, how can you say that the best thing aji jemti apan mane konosi analogous matter re gote order pass hele deucheni sir ei type ro order ti heichi ame dekhuchu jodi state be verify କରୁଛନ୍ତି identical matter same order to be passed, matter would have ended there. But ଆପଣ ସେଠି କିଛି କହିବେନି, ଏଠିକି ଆସି ଆମେ କଣ ବର୍ତ୍ତମାନ ତାଙ୍କର original application ଦେଖିବୁ, ସେଇ ଯୋଉ ମାନଙ୍କର notice issue ହେଇଛି ତାକୁ verify କରିବୁ, ଆପଣଙ୍କ original application ଦେଖିବୁ same କି ନାହିଁ, ତାପରେ ପଚାରିବୁ ଯେ ସେଠି ତ ଏମିତି order ହେଇଥିଲା ଏଠି କେମିତି ଏଗୁଡା କଣ ଆମର କାମ?
No, Your Lordship, Your Lordship, I am just praying for a liberty. And Your Lordship are saying that whether the order of the OA, which I am placing before Your Lordships, whether those are similar to the cases of the present petitions or not, I can show you, Your Lordship, from this very point.
No.
Because, Your Lordship, in the year 2013,
we are concerned with the legality or illegality of this impugned order.
Your Lordships are.
As such, we do not find anything. If you want to file any application, it is up to you. We cannot give you liberty because an order has been passed unless it is set aside or remanded back to the state court. Matter is different. Otherwise, we cannot do. show us the illegality in this order.
Your Lord,
We
your
cannot
Lordship,
pass that
was
order
what your
without anything. We'll set aside the order and permit you to file a better writ petition. How can it be?
Lordship, sir, because that is
No, no,
the
because-
position of, because the Lordship, sir,
Sorry,
that
sorry.
office memorandum is still, the cases are, the matters of similar place, workmen are still pending before the learned cat, and which is sub judice, your Lordship. So, your Lordship, unless and until I get the liberty,
File an application to recall that order and IA file କରନ୍ତୁ ବା review ଅଛି review file କରନ୍ତୁ ସେଠି file କରିକିନି ସେଇ ଯୋଉ grounds ଗୁଡାକ ଏଠି ବର୍ତ୍ତମାନ submission କରୁଛନ୍ତି ନିଅନ୍ତୁ ସାର୍ ଏଇ ଗୋଟାକ similar matter ରେ notice issue କରିଥିଲେ ତେଣୁ order ଟାକୁ recall କରାଯିବ review କରାଯିବ review provision is there or not?
Your Lordship, may I pray something, your Lordship? Can the matter be taken up tomorrow? Because I can ask my senior to appear, your Lordship.
No,
The order will be the same.
Lordship, I'm just praying for a short
you are
action.
not aware that whether the statute central
Your
that
Lordship, even if a review is maintainable, your Lordship, it is to be filed by the conducting council who was before the central, because the new council has.
no, we are asking a question whether any review application against an order passed is maintainable before the tribunal or not.
That
is to be verified also.
Your Lordship, kindly give me a short adjournment till tomorrow. I'll ask my senior to appear in this one.
Put up this matter as prayed for. Is this matter on 16th of April 2025? Yes. As a memo of appearance on so file, the name of the land and council be reflected. So hold on, Chari, yes. What is your name, land and council?
Your Lordship, Shamsundar Tripathi.
Shamsundar Tripathi. Yes.
Obliged.
Item 17.
So here is the case where the minor mineral lease was granted to the petitioner. That was from 10/5/22 for a 5-year period till 9/5/27. So the first instance, because the royalty and all the charges has to be paid in advance, we paid and operated it, but at that point of time, the Syrup was under the Tahsildar. So there was no EC requirement was there. Later on in 2024, the in 22 the requirement of EC came later on. So after that, so operation stopped from 22 because of the EC was not there. So I applied for the EC, and ultimately the EC was granted on 10/1/24. So when I made the application to allow me to operate, so your lordships may come to Annexure 6. They gave a demand note. So the demand note, my lord, there was a small error in the demand note for which I raised an objection, and I said that I'll pay this amount. Why I'll, my lord, explain before your lordships, which was not accepted by them, that we cannot take anything below this amount, so we will not accept your payment. So your lordships may come to section 32 of the Orissa Minor Mineral.
No, you earlier also approached this court.
Yes, my lord, but that is in a
What
different,
happened?
no, that is training that is in a different context, not directly regarding this order. So this is the order which has been passed.
No, the
Demand.
the very letter
Yes,
which you are showing to us, demand notice, that was also the subject matter in
Yes, yes.
writ petition.
yes,
And the order has been passed that petitioners shall be at liberty to raise all
File an-
raise
file an appeal.
Yes, post office.
Yes, appeal. So what
appeal
happened?
has been filed.
So what happened?
In the appeal, my lord, the provision is that the entire amount which has been demanded has to be deposited. So the error in the demand order, my lord, I want to point out why my appeal has not been entertained till date. If your lordship should come to section 32 of the
appeal has not been numbered also.
Not been numbered because the deposit has not been accepted. That is a precondition.
Yes.
Because the appeal memo has
Let us see that provision.
Yes.
Hey,
Section 32 of the Rule 32 of the Orissa Minor Mineral Concession Rules.
Yes. Thirty
32
rules.
liability for payment.
Just. Yes. Your lordships may come to this second, my lord, 32(2) second proviso. Provided that the rates specified in Schedule 1 and Schedule 2, maybe that is first proviso, second, my lord. Provided further that where the lessee becomes liable for payment of royalty for any minor mineral removed or consumed by him or his agent, manager, and employee or the contractor from the leased area, he shall be liable to pay either the royalty or dead rent, whichever is higher. So it has to be either of them, not both. Now, in the demand order, if your lordship should see.
No, where is the appeal provision?
Appeal provision, my lord, section, that is rule 42, 46.
Yeah.
That is rule 46(2). No appeal shall be admitted unless the amount, if any, assessed in accordance with the provisions of these rules as per orders has been deposited. So the entire amount has to be deposited.
Yes.
So if your lordship should come to annexure 6 at page 42, where the tabular form is given regarding the demand. Both royalty and dead rent has been included. So when we pointed out that both should not be demanded from us.
So in such a eventuality,
we are ready to pay the higher amount.
No, in such a eventuality, what is the way out? Suppose there is a dispute with regard to this or area.
No. In that case, that is a different issue, my lord. That if there is regarding the area and all.
That comes to 46(5).
Yes.
So that also speaks about the dispute regarding the dues.
Yes, my lord.
Yes.
So appeal we have filed.
No, that is all right. But then appeal will not lie. You have to approach the civil court.
That is so far as the dues, if at all. But here we have not yet extracted.
No, in the event of any dispute relating to the area, conditions, the dues payable
or any other
matters. So any other matter, if dispute is there, the prospecting licensing, mining prospective licensing, mining lease or mining lease or quarry lease executed for the purpose, the suit or appeal only in the civil courts.
Yes, I am not disputing the amounts. Then what I am saying is it should be either. It is not both. So I am ready to pay. That is why my prayer is the dead rent, which is lesser the amount, royalty is more in the assessment. I am ready to pay that. I am not disputing the quantum or the amount also.
No, suppose there is no such thing that discretion has not been given to the appellate authority to reduce that amount. Is it your submission?
No, my submission is if the demand order as per should be in conformity with 32. Then only the appeal.
The appellate court will adjudicate the matter, whether the demand was proper or not, or it is to be reduced, whatever it may be.
Yes.
But the question is that once the requirement is that you are to
pay the entire amount regarding the demand.
Suppose any application is made that we are for the time being we are depositing this amount.
We proposed that, but that was not accepted.
No, we do not know that. Where is that application?
Where is that?
Where is that application?
Application we have not made. We made the submission before the appellate authority that we are ready to pay. That's what
personal interaction or
no, my lord. That is why my prayer is royalty, which is the higher amount which has been assessed.
You file an application.
All right.
In case they refuse that.
They refuse.
All right, that liberty may be granted, so that on the basis of this section 32, we can move an application before the court.
He has actually prayed at annexure 9 before the Deputy Director Mines. I may be allowed to operate the center and I promise to abide by any terms and conditions.
We are not on that.
That is
the appeal may be directed, my lord, to let him deposit the
fees. Let him?
They are ready to deposit. It is
ready to deposit a higher amount.
Except the dead rent. They say the except dead rent.
This writ petition has been filed by the petitioner S.K.Sahoo with a prayer for a direction to the opposite party number 5 mining officer Qatar to allow the petitioner to perform mining operations over the area, namely Birupa River Sand Bhattimunda in Mauja Bhattimunda, Khata number 441, plot number 1116, Kisham Nadi, area, acre 12.34 decimal, बाकी जहाँ लिखा है लिख देना है ना. It appears that
What is the appeal number?
Appeal number has not been given.
Oh, Delle nahi.
the learning counsel for the petitioner submits, learned senior advocate submits that a demand notice dated 18/3/2024 was issued by the opposite party number 5 to the petitioner under Annexure 6, and the said notice was challenged before this court in WPC number 12919 of 2024, and the petition was disposed of by order dated 18/6/2024 without going into the merits of the contention raised in the writ petition, giving liberty to the petitioner to raise all the pleas as taken in the writ petition before the appellate forum. If any appeal is filed, the learning counsel for the petitioner submitted that in view of section 46 of the Odisha Minor Mineral Concession Rule 2016, year after 2016 rule, he has referred the mineral concession appeal number dash of 2024 on date के बे
July just
date again
10/7/24 mentioned at page 50, running page 55.
10/7/2024. But since subsection 2 of section subrule
Proviso to second proviso to subrule 2 of Rule 32.
No, this appeal was not entertained because you have not.
Yeah,
That is in
that
accordance
is true,
with
sir. That is subrule 2 of 46.
Subrule 2 of section
Second.
Achha. In view of the second proviso to subrule 2 of Rule 32 of 2016 rules, it states that where the lessee becomes liable for payment of royalty for any minor mineral removed or consumed by him or his agent, manager and employer, or the contractor from the leased area, he shall be liable to pay either such royalty or dead rent, whichever is higher. But so far as the case of the petitioner is concerned, he has not removed or consumed any minor mineral, and therefore the demand notice which has been issued under Annexure 6 is not sustainable in the eye of law. And since in view of subrule 2 of Rule 42 of 2016, if he is compelled to deposit the entire amount assessed under Annexure 6, he will be seriously prejudiced. the land and counsel for the senior advocate, after arguing for some time, seeks liberty to file appropriate application before the appellate authority to reduce the amount and to permit the petitioner to deposit kete kouchandi tara de
entire except the dead rent.
Dead rent.
Because royalty is higher.
Entire amount except
So we are ready to pay the higher amount.
Just a minute. Entire amount except the
Dead rent.
dead rent. And the appellate authority may be directed to consider the same in accordance with law. The land and counsel for the state has no objection in view of such submission made by the land and counsel for the parties. The writ petition is disposed of, giving liberty to the petitioner to file appropriate application in the appeal which has been filed under Annexure 8 before the appellate authority. Accordingly, the writ petition is disposed of.
What is the time schedule if at all can
You
be?
file the land counsel for this one, so submit that you will file such application within a period of
1 week.
1 week. If any such application is filed, the same shall be disposed of expeditiously as possible, preferably within a period of 1 month from the date of presentation of this one.
Yes. In fact, my lord, I asked the client that why don't you pay? This is not the big. This is not every year the same thing is being perpetuated. So by the time the entire period is covered, their profit is taken away either way. Obliged.
Yes.
Item 18.
File a petition, the memo, even the writ petition has been filed with following prayer. The land and counsel for the petitioner files a memo to withdraw the writ petition. Memo is taken on record, writ petition is disposed of as withdrawn. Yes.
Item 19.
Liberty to file application under section 64 of the right to practice.
Yes, that's it.
The writ petition has been filed by the ଗୋଟେ order ଆମେ pass କରିଥିଲୁ ଆଜି କେତେ number ସେଟା କିଏ ନେଲେ
64
64
provision 64 would apply.
ଏଇଟା ବୋଧେ item number 12 କି କଣ
14, 15, 16 last.
ଗୋଟେ ଅବିକା dispose of କଲୁ ଯେ 64 ରେ provision ଅଛି he can approach it, maybe item number 12 ଟା ଟିକେ verify କରିଦେବେ ହେଲା ବୋଧେ ସେଇ type ର order ହେଇଛି ହେଲା item number 12 ଯେ ସେ prayer portion ଲେଖା ହେଇଛି ତାପରେ 64 provision ଟା quote ହେଇଛି ତାପରେ ସେ withdraw କରୁଛନ୍ତି seeking liberty to approach this one, so accordingly disposed of କରାଯାଇଛି ହେଲା ତେଣୁ ସେଇ withdraw ସେଇ ଅନୁଯାୟୀ item number 12 ଟାକୁ ଦେଖିଲେ ହେଲା. All right, next.
Item 20.
Item number 20 seeking for passing.
Speaking.
For passing.
Well, in this case, I'm appearing for the open number 1 to 3.
No, he will give the he just wants a passover. No? Yeah.
Item 21.
Later, just wait for it.
Well, can you take over after
No, after that there is a separate
branch.
The counsel may be held up in some other court. He's just seeking for a passover. Just wait for some time. Yes.
Item 21.
Matter regarding similar matter
Yesterday we were disposed of.
28 posted to 21 on that.
Let us see, हमको मांगे थे ये LO 28 you dispose of the
काली एमती मैटर थिला
Yes, sir.
कितने नंबर आइटम
Item number 21st to
this कौन ऑर्डर है
21st to खाली स्टार्ट करना है
ये काली को मैटर टा कोचन देखिल ता कॉज लिस्ट दे दियो ये देखिन कौन तो सेट अप ऑर्डर टा कौन
so item number 21 and 20
and 21
only
only
24 is different but that is content
तो कॉज लिस्ट ता दियो please verify the cause list and tell which is that item.
Yes, sir.
Because similar order is to be passed. So cause list টা নাই।
That should be
You can take
26, 27, 28.
just a minute.
26, 27, 28.
Second half.
Second half. 26 हाँ ये right 26 27 28 order कौन है देखिए गोटे item रे 9751 of 25
And 23.
हाँ
23, 26, 27.
कबले तो order issue WPC बाहर करो
Yes.
हाँ
9587.
item number 23 टा होची
9587.
9587 करो 9587 ଆଉ ଏଟା ହଉଛି year ଟା ହଉଛି 2025 ହଁ
କଣ ହଉନି କଣ ସବୁ ତାହେଲେ ଆମେ ଏତେ ସାଇନ୍ କରିକି ଯାଇଛୁ ସବୁ କରିଛୁ
order upload ହଉନି ହଁ ଦେଖ ମୁଁ ପଚାରୁଛି ପୁରା କେତେବେଳେ ତମେ ଯାଅ upload କରିଦେବ order upload ନ କରିବା ପର୍ଯ୍ୟନ୍ତ କୌଣସି ଲୋକ ଯିବେନି କୌଣସି stand otherwise we will proceed against that है ना we are signing the order and you are not uploading yes
Item 20.
item 20 it was passed over argu
Item 20.
Your Lordship, I'm challenging the order dated 29/10/2024 passed by the learned Central Administrative Tribunal, Cuttack, Your Lordship. Your Lordship, the impugned order is on page 54 and 55, Your Lordship. Your Lordship, the brief fact of the case is that the petitioner had filed an OA before the learned Central Administrative Tribunal.
there is no 55 there is only 53 and 54 two pages of
53, 54.
and what was your prayer before the land tribunal
Your Lordship, my prayer before the learned tribunal was for the supply of the documents as relied upon by the department.
have you filed a copy of the OA
Yes, Your Lordship.
let us come to that relief sought for
Page 23, Your Lordship.
page 23 please place that portion
Yes, Your Lordship. In view of the facts and stated above, the applicant prays for following reliefs. It is therefore most respectfully prayed that this honorable tribunal may be pleased to direct to the respondents, particularly respondent number 2, the Director of Postal Services, the Chief PMG Orissa Circle Bhubaneswar, to supply the copy of content of the call recording and phonic conversation stored in the pen drive as document at serial number 57 in Annexure 3 of Memorandum of Charges as requisitioned in Annexure A by 3, Your Lordship.
ଏରା କଣ ହେଇଛି କଣ ଚାର୍ଜ ଆପଣଙ୍କ against ହେଇଛି
Your Lordship, there were 5 articles of charges, Your Lordship, alleging various misconduct, Your Lordship.
কি প্রকার misconduct?
Your Lordship,
কোন কল কোন দরকার কোনটা ইজি
Your
ব্রাইব
Lordship,
ব্রাইব অ্যামাউন্ট ডিমান্ড না কোন
no, Your Lordship.
কোন
So it is in the midst of the inquiry proceeding that you has come.
Yes, Your Lordship.
So what's the ground?
so why it was rejected by the tribunal?
Yes, Your Lordship. Your Lordship, the tribunal had passed an interim order, Your Lordship, that no coercive action may be taken against the applicant. Thereafter, an MA was filed by the department for the vacation of stay. In the vacation of stay, Your Lordship, the department submitted that the document that is being referred has been submitted. Hence, the interim order may be vacated. However, Your Lordship, the only point of consideration here is that as per the prayer, the relief sought for by the applicant, Your Lordship, the prayer was to be granted with the document as per Annexure A by 3, Your Lordship, which was the representation, in which the petitioner had prayed for the phonic conversation as was being relied upon by the department to prove the charge, and the authenticity certificate to prove it, and the transcript, Your Lordship, so that it can be relied upon by the petitioner in defense of its case, Your Lordship.
Please come to paragraph number 3. Why they filed the application to vacate order? Interim order was passed in your favor,
Yes, Your Lordship.
right? Come to paragraph number 3 of the order dated Annexure 3.
Yes, Your Lordship.
By filing MA number 292 of 2024, the respondents have prayed to vacate the ad interim order since the document shown at serial number 57 of the memorandum of charge has in the meantime been supplied to her in the pen drive, while later number so which she has received on 5 to 2024,
Yes,
and the departmental proceeding are to be completed. So if it has been already supplied, that was your main prayer.
Yes.
Now what can be your grievance here?
My main prayer, Your Lordship, was for the supplying of the document that I had seeked from the department, Your Lordship.
No, please see the original application.
Yes, Your Lordship.
Please see the original
At
application.
serial number 57 was the only document.
As requisition in Annexure A by 3, Your Lordship.
No,
A by 3 was
come to the relief sought for. That is why we asked you to place the relief sought for.
Yes, Your Lordship.
The relief sought for is to supply the copy of the content of the call recording and phony conversation stored in the pen drive as per listed document at serial number 57. That has been supplied to you.
Your Lordship, it was as requisition, and the later part is as requisition in Annexure A by 3. Your Lordship, A by 3 was my representation. The department is well aware, Your Lordship, the representation was pending before the department, in which I had specified 3 documents, Your Lordship.
We do not know if would have made a specific prayer in that relief sought for. We want not only the pen drive but also a B, C, D.
I have annexed that representation. I had annexed it in the.
Suppose a particular document has been relied upon by the disciplinary authority and they have supplied you. That is one part. One document that you intend to bring on record.
Yes.
If it is not given to you, there is a prejudice.
Yes.
You take advantage of that. At this stage, how can we say? How can we compel them to file a particular document which they have not relied? You have relied.
Yes, because Your Lordship, I had prayed for the same.
Maybe.
And
So,
there is an
so,
office
so it's
memorandum.
all right. It will go in your favor.
It is also.
If it is not supplied to you, it will go in your favor if it is utilized by them.
So you are not disputing that the pen drive has been supplied to you.
Yes, Your Lordship.
If you say that suppose A and B are the 2 other documents,
Yes.
which as per your representation should have been supplied to you, and they have not supplied to you. So as has been pointed out to you, if they utilize those documents against you not supplying the same, so that can be a very good ground in future. Why are you
because Your Lordship, unless those documents are supplied to me, Your Lordship, I'll be deprived of an opportunity.
But how can we compel them to file a document?
Your Lordship, there is an office memorandum, Your Lordship.
All right, they are suppressing it. According to you, they are suppressing it.
Yes,
let them suppress.
But there is a office memorandum with state.
You come to that Annexure A by 3. That is your representation?
Yes, Your Lordship.
Please come to that. That is at page number, running page perhaps 43. Annexure A by 3. Please read it out.
Most respectfully and with humble submission, I, Srimati Rubidas, Inspector of Post, Forasai Sub Division, beg to lay before your honor the following few lines for kind consideration and favorable orders.
Yeah.
That I have received all the listed documents on 28/8/2023 without the pen drive as per the listed document serial number 57 in 3 of the charge memo. Kindly provide the transcript of the conversation between me and Shri Sudhanshu Kumar Acharya, copy of the authentication certificate obtained from the competent authority as required under law. Further, I may kindly be granted at least 20 days extension from the date of completion of 15 days from the date of receipt of the copies of the listed documents, or a grant of 4 days off and oblige.
So the pen drive has been supplied to you.
Yes, Your Lordship.
Transcript of the conversation which was stored in the pen drive,
Yes,
that has not been done, and the authentication certificate is not there. So what they said when they filed the MA, what was their stand for vacation of that order?
Since they had the pen drive,
57. Serial number 57.
So what is your submission, learned counsel? You see that annexure A by 3. There are virtually 3 prayers in that. One is pen drive, the other is transcript of that conversation, the third is the copy of the authentication certificate. So is it not correct, as she submits, that you have only supplied annexure that pen drive only, not the 2 other documents?
My lord, as for the first prayer, he filed original application before the central arbiter, London Central Arbiter Tribunal, and this London Tribunal already disposed of this para 3. You already read this para 3. I have already supplied the documents by the pen drive.
ଆପଣ pen drive ଆଉ ଯୋଉ ଦିଟା ଡକୁମେଣ୍ଟ କଥା କଣ ହେଲା, ତାଙ୍କର ପ୍ରେୟାରରେ ଅବଶ୍ୟ ସେଇଟା ସ୍ପେସିଫିକ ଲେଖିବା କଥା, ସେ ଗଣ୍ଡଗୋଳ କରିଛନ୍ତି ଆକ୍ଚୁଆଲି ସେ ରିଲିଫ ସର୍ଟ ଫୋର ରେ କେବଳ ଲେଖିଛନ୍ତି ପେନ୍ ଡ୍ରାଇଭ ହାଇଲାଇଟ କରିଛନ୍ତି, ବାକି ଲେଖି ଦେଇଛନ୍ତି pen drive as per the listed so and so memorandum of charges. ଆଉ କିଛି ଲେଖି ନାହାନ୍ତି. Madam, what lies with you?
Your Lordship, I have told you respect, Your Lordship, I have mentioned as requisition in the
ଆପଣ
annexure.
କହୁଛନ୍ତି ସେଇ ଯୋଉ annexure 3 ରେ ଯୋଉ ପେନ୍ ଡ୍ରାଇଭ ଟା ଲେଖା ହେଇଛି ମତେ ସେତିକି ଦିଅନ୍ତୁ, ସେ ସେତିକି ଦେଇଦେଲେ। ଆପଣ ଯଦି ଲେଖିଥାନ୍ତେ ରିଲିଫ ସର୍ଟ ପରେ ଯେ ପେନ୍ ଡ୍ରାଇଭ ଏବଂ ଏଇ ଯୋଉ ତାର ଡିଟେଲ କନଭରସେସନ ତାର ଯୋଉ ସାର୍ଟିଫିକେଟ ଯେ as mentioned in annexure 3 may be supplied, ତାହେଲେ ସେଟା ହେଇଥାନ୍ତା। ତେଣୁ ଆପଣଙ୍କର ସେ ପ୍ରେୟାର ଟା ରହିଲାନି। So what
Your Lordship, that annexure 3 had made a part of the OA, and even while opting to the MA,
no, annexure 3 ର ଯୋଉ ପ୍ରେୟାର କଲେ, the tribunal may be under impression that perhaps you have received the other 2 documents except the pen drive as per annexure A by 6. That is why you have not prayed for.
No, Your Lordship.
While
it has been mentioned in the order, Your Lordship. While objecting, the petitioner had objected that the other 2 documents have not been supplied, Your Lordship. In paragraph 4.
Paragraph 4 कौन कहले आपण?
Learned counsel for the applicant has opposed the prayer made in the MA by stating that she had received the document shown at serial number 57 but without any authenticity certificate, and therefore the same cannot be
authenticity certificate gotiye matra कहले, but there are 2 other things apart from authenticate certificate. There was a prayer कोटा गला सेटा annexure A by transcript अछि सेटा मागिलेनी कोन सबमिशन भी सेटी गोटे अलगा टाइप रो कहउचंदी।
Lordship, my prayer is that
page 49. Para 3. That it is humbly submitted that the input document, that is the copy of the content of all recording and phonic conversion stored in the pen drive, as per listed document serial number 57 of the annexure 3 of the memorandum of charges has already been
That
supplied.
is already read.
That is all.
So we have read.
Your Lordship.
Just a minute. This writ petition has been filed by the petitioner Ruby Das, challenging the order dated 29/10/2024 passed by the London Central Administrative Tribunal, Cuttack Bench Cuttack, in OA number 19 of 2024. It appears that the petitioner filed the aforesaid OA with the following prayer. Quote कर देबे, relief sought for a जोटा अच्छी, page number 23 रे, है ना? सेटा quote कर देबे. It appears that by order dated 19/1/2024, while allowing time to the respondents to file the reply to the original application, by way of ad interim measure, the respondents were directed not to take any coercive action against the applicant till the next date. Stop. MA number 292 of 2024 was filed by the respondent to vacate the ad interim order, wherein in paragraph number 3, it is stated as follows. The entire paragraph number 3, page 49 of annexure 2. Stop. The London counsel for the petitioner submitted that under annexure A by 6, page number annexure A by 6.
A by 3.
A by 3. A by 3. 43. A by 3, which is annexed to the original application. The petitioner submitted a representation before the Director of Postal Services, bracket headquarters, seeking for the supply of pen drive as per the listed document serial number 57 in annexure 3 of the charge memo, এটা Roman 1 further, Roman 2, and transcript of the conversation between Hor and Hor and Sri Sudhanshu Kumar Acharya, and Roman 3. Copy of the authentication certificate obtained from the competent authority as required under law. However, the contention was raised that the authenticity certificate has not been supplied to the petitioner, and therefore, till the supply of the authenticity certificate, the interim order should be allowed to continue. The London Tribunal take note of the submission, and after perusing the report, has been pleased to observe that, since the main prayer of the petitioner the applicant in the way was to direct the respondents to supply the call recordings and phony conversation stored in the pen drive as per listed document at serial number 57, and the same has already been supplied, which is not disputed by the petitioner. There remains nothing to be adjudicated in the original application. Accordingly, the MA number 292 of 2024 filed by the respondents was allowed, and the ad interim order dated 19/1/2024 was vacated, and the way was also disposed of as infructuous. The Sardavala General and Counsel appearing for the petitioner submitted that in view of the averments taken in the MA, it is clear that even though the petitioner has sought for 3 documents, including the pen drive, but only the pen drive has been supplied, not to the other 2 documents. And therefore, the order of the Learning Tribunal is not sustainable in the eye of law. The Learning Central Government Council, CGC, Learning Central Government Council, on the other hand, supported the impugned order and submitted that in the relief portion, it is specifically mentioned for supply of only the pen drive. Nothing has been stated about the other 2 documents, which are there in annexure A by 3. And therefore, when the said pen drive has already been supplied, which is not disputed by the petitioner, the further prayer of the petitioner to supply him the other 2 documents should not be considered. Considering the submission made by the Land Council for the respective parties, we are of the view that whatever the prayer was made in the relief shortfall, that has been taken care of by the respondents in supplying the pen drive, and if any documents have not been supplied in spite of prayer, the petitioner can take the advantage of the same at a later stage of the disciplinary proceeding. We are not expressing any opinion on the same. We find no illegality or impropriety in the order passed by the Learning Tribunal. Accordingly, the petition being devoid of merit stands dismissed. Give the names which is to be mentioned there. Yes, next. Okay.
Item 22.
Merit the action of the opposite parties in appointing the petitioner in a lower rank, which amounts to reversal, which is violating also Article 311, was the subject matter of challenge with the London Central Tribunal. My interim relief was rejected. That is how I am before you.
Which is the order you are challenging?
Annexure 1. Before that, before showing the impugned order, may I draw your attention to page 47?
No, we to first know that what was your prayer.
Madam,
what is the original application?
Yes, madam, that is that page, madam, 85 you will check my list.
85.
85, running page 85, that the relief shortfall.
Yeah.
It is therefore humbly prayed that this honorable tribunal may be graciously pleased to admit this original application and call for records from the office of the respondents, holding and declaring the action of the respondents as illegal, arbitrary, and contrary to Article 311 of the Constitution of India, was the impugned orders dated
6/12/2024 on Annexure A by 1, 30th December 2024, and 12/12/2024 on Annexure A by 5 series. B.
What are those orders? 6/12/2024.
That is what I'm showing, my lord. That is the order issued by the aspect page 47, my lord.
May I submit just a minute, my lord? I am just disturbing. My lord, it is against the interim order, and the for filing counter it is fixed to 17/4/2025. 17 the next date. On that day they will file the counter. This is the order, my lord. See page 40 and page 41. Against the interim order, they come to the High Court. Matter is pending before the tribunal, and the next date is 17.
Yeah. Okay. So we are taking up this matter. Then on 21st, you file the counter affidavit in the meantime.
My lord, may I have a little prayer, my lord? In the meantime, my lord, let's look kindly see. In the meantime, my lord, certain developments have supervening circumstances cropped up. That is why I filed a miscase. I'll serve a copy on the SGA.
The writ petition has been filed with following prayers. At the outset, Mr. Pari, Learned Deputy Solicitor General, submits that he has received instruction that the original application is posted to 17th of April 2025 for filing.
It is order itself. It is in the order itself on page 40.
The order reflects that the case is posted to original application is posted to 17/4/2025 for filing the counter affidavit. The learning counsel for the petitioner has filed consent affidavit. An interim application in court today.
Para 3 Para 3.
With some prayer, let the IA be registered. Copy of the interim application be supplied to the Learning Council for the Union of India. Matter be listed on 23rd of April 2025. The Learning Council for the Union of India shall apprise this court whether the counter affidavit has been filed or not. Yes, next.
Another little prayer, my learned senior Mr. Pari may take instruction on the annexure 1 by A.
All I do will see that is next.
Let them serve a copy. I didn't have a copy.
We have already passed the order, Mr. Pari, that it will be supplied by tomorrow. We mention it by tomorrow. It will be supplied. Next.
But on he may take instruction on annexure 1 by A.
Yes, next. Item number 23.
Item 23.
Yeah.
Please, Your Lordship.
Yeah.
Lordship, the land of the petitioners have utilized for the construction of MDR 77, that is Major District Road 77 from Cuttack to Simar via Banki. The original, it is gradually, the lands are gradually taken up. Originally in revenue record, the road was 30 feet, and in 2004, 2008,
Will you come with such a matter day before yesterday, I think, or last week? एक टाइप रोड मैटर अपन फाइल करते ले बरा what order was passed?
That is for embankment.
And this is
this is
road.
This is road.
Same. What is that order? What is that order? What is that item and what order was passed?
The order was passed for to take instruction.
Please show us that order. That we are keeping this matter. Please bring that order. Land Council for the petitioner 6/4 placed this matter on 16th April 2025. We are just coming within 2 minutes.
Item 24.
22 होगा ना?
No, 23. 23 होगा.
24. Yes, Mr. Behera.
He is not there. Compliance is
कौन सा हुआ?
They have stated that it is a interdepartmental, the interdepartmental approval and implementation order will take some time. That's the timeline.
So the prayer was the order that was passed under Annexure 1 that opposite party number 3 was directed to dispose of earlier case number 65 of 2017 in accordance with law within a period of 3 months from the date of production of this certified copy and communicate that order to the petitioner. That is one thing. Further directed, and in case the application of the petitioner under so and so is allowed, and if there is no legal impediment, the compensation amount to be disbursed. So the question is that whether LA has been disposed of or not. What is your instruction? He has stated that I have given that copy of the order to the authority and
that was decision.
so now you are supposed to dispose of it within 3 months. So whether you have complied it or not, that is why we sought for instruction. Opposite party number 3 is
that is a
opposite party number 3 is Special Land Acquisition Officer, Lower Indra Irrigation Project, Khariar, Nuapara.
present the instruction has been provided by the director from the resettlement from additional secretary to government.
Earlier case ro position ta kon kohunati?
Position whether is declined, কিন্তু they will implement for that.
They have sought for time to intimate the status of
At least source kon hai. Order ta thila dispose of karibe au jodi allow hela ta taku disbursement karibe. Is being implemented in letter and spirit माने कौन कर देसी माने एलआर केस रो किसी रिजल्ट देखलेनी कौन हला अलाउ हला कि नहीं अब्स्ट्रक्शन कौन पे आनु नांती ए टाइप रो ए जो ऑर्डर टा पढिले ए टाइप रो भेग टाइप रो जो रिप्लाई दउचंती इज बीइंग इम्प्लीमेंटेड इन ऑर्डर टा हेचा गोटे पर्टिकुलर केस टा को एलआर केस टा को डिस्पोज ऑफ करिवे से लिखिलेनी एलआर केस हम डिस्पोज ऑफ करिछु कि नहीं जदि डिस्पोज ऑफ करिछु consequential step भी निया आइची and it will take some time matter how the order of the court is being implemented in letter and spirit तापरे involves interdepartmental swan एगुड़ा कौन एगुड़ा सो you obtain the specific instruction see the order and what we that is why contempt petition has been filed.
Comply then further time for that has been fixed by
the Learned Counsel for the state submits that though he has received the written instruction dated 18/3/2025 from the Director R&R from Additional Secretary to Government, but the same from the same it doesn't appear whether the order dated 17/5/2024 passed by this court in WPC number 12347 of 2024 has been complied with or not, and he may be given some more time to obtain specific instruction in that respect. List this matter in the week commencing from 5th May 2025.
Item 25.
My lord, on behalf of S.K.Sahoo Hon'Ble, my lord, great time.
Just a minute.
I guess time was so here.
We wanted to know that whether the order dated 2/5/2024
Was served.
has been served on the concerned opposite party or not, and you are supposed to file the affidavit. केबे सर्व कले आउ कोभଳି सर्व कले registered post ना in person जाइकिनी कारण डेट काउंट होबो सेही दिन है ना 3 months from the date of production of the certified copy of the order by you, that is to be counted. So you are to say on which date that order was handed over or served on the opposite party number 4. ସେତିକି ପାଇଁ affidavit ଆପଣ ଦେବେ ଦେଇନାହାନ୍ତି ଲେଖିନାହାନ୍ତି ସେ ବିଷୟରେ content petition. So what do you want now?
Some family, over phone, he told me to take some time.
All right, we are adjourning the matter, but this is the order. You are to file an affidavit just now. The कारण आमे अपन affidavit देले ही आमे state को कोई भी instruction ना होता है, right? Look, the learned counsel for the petitioner. You are mentioning on behalf of Mr. Shrikant Mahal. What is your good name?
My name is D.S. Rao.
Please give it in writing. Appearing on behalf of Mr. Shrikant Mahal, seeks for an adjournment to file an affidavit in consonance with the order dated 18/3/2025. Place this matter on 5th of May 2025. Yes.
Item 26.
ଏଥିରେ ବି ଥିଲା ଆପଣଙ୍କୁ instruction ଆଣିବା ପାଇଁ ଆଣିଲେ ଆସିନି status of representation. ମସିହାର ରିଟ୍ ପିଟିସନ 19/12/2022 ରେ ଅର୍ଡରଟା ହେଲା ଗୋଟେ ରିପ୍ରେଜେଣ୍ଟେସନ ଡିସ୍ପୋଜ ଅଫ କରିବାକୁ 3 ମାସ 4 ସପ୍ତାହ ଭିତରେ from the date of production, and we are in 2025 April. ତେଣୁ ସେ ରିପ୍ରେଜେଣ୍ଟେସନ ଟାକୁ ଆପଣ ଡିସ୍ପୋଜ ଅଫ କରିପାରୁନାହାନ୍ତି ଏପର୍ଯ୍ୟନ୍ତ ଯୋଉଥିପାଇଁ ସେ କଣ୍ଟେମ୍ପ ପିଟିସନରେ ଫାଇଲ କରିଛନ୍ତି and you are seeking for time. It has already suffered 3 adjournments. Today is the 4th date. We are granting you adjournment till we are listing it on 22nd. All right. The learned counsel for the state seeks some further time to obtain instruction regarding the status of representation filed by the petitioner. Of this matter on 22nd of April 2025. Hello? Yeah.
Item 27.
Can you give the order dated 28/18 March? Second paragraph, my lord. The amount of compensation
Wait.
which is in deposit.
Just a minute. This AHO has been already disposed of. So what is the order passed in the AHO?
28/6/18 March. Only 3 line, 4 line order. Second paragraph.
the amount of compensation which is in deposit with the register judicial of this court may be disbursed to the respondent in terms of the award along with the accrued interest. In fact, on verification, I came to know that the amount is not lying with good mileage. But which the claimant is not getting much.
So it is not with the registered judicial. Where from the court got the
My lord, I have also intimated the counsel is not coming. Said that they have already entered file as returned back to insurance company. May submit mala issue notice to the insurance company whether they have deported or not.
In this IA, you have stated all those things.
Yes, madam. On verification of case came to know such amount is not live. I have verified twice, my lord. The file was missing for 2 or 3 years, my lord. The recent file was rest of my life.
By deleting number.
No, what you have stated in paragraph number 3 of your interim application?
My lord, the counsel was that submitted the amount is lying here.
No, it is the fault lies with you. You submitted, you are the claimant, na?
Yes, ma'am.
So you submitted that the entire amount is lying with the registry.
Yes.
So that is why the order was passed.
My lord,
So now you are shifting the blame to the other side.
when I filed the refund came to Nana, initially in appeal, my lord, I was not the counsel, my lord. The other counsel is there. He has given a notice that amount is live. That's why the counsel appearing in the HO, he has stated the amount is lying here.
So where is the order? You misappeal number. You
Dismiss file the insurance company.
Insurance
was file appeal that has been
order copy gain.
Order copy gain. Misappeal number 6. Misappeal. এই অর্ডারটা তো আপনাদের ফেভারে গলা মানে it was the national insurance new India insurance company preferred that appeal.
That was dismissed. Against that they have preferred HO.
That was also dismissed. All right, take down IA number 17 of 2019 is an application for modification of the order, modification of the recall of the order dated 28/6/2018 passed by this court in HO number 149 of 2001 by deleting the award amount deposited with the registry may be released in favor of the claimant respondent number 1 and 3 and 5. Stop. से जो MA प्रश्न it appears that misappeal number 647 of 1996 was filed by the New India Assurance Company challenging the order dated 29/7/1996 passed by the Third Motor Accident Claims Tribunal Balashur in MACT number 136/139 C of 1992/1991 in awarding a sum of rupees 1,15,200 as compensation to the claimants. Stop. Para. By judgment and order dated 19/7/2001, the said misappeal number 647 of 1996 was disposed of and the appeal was dismissed. Challenging the order passed, judgment and order dated 19/7/2001 passed in misappeal number 647 of 1996. The New India Assurance Company Limited, New India Assurance Company filed AHO number 149 of 2001. The said AHO was disposed of by order dated fine. We should have. এটা কোন ওটা পড়াটা কেবে ডিসপোজ হলো না
2818
ତାପରେ ଗୋଟେ କଣ ଅର୍ଡର ପାସ୍ ହେଇଛି
Modification was filed, one of the claimants was died.
The HO order কথা না the HO was disposed of by order dated 28/6/2018 है ना and it was observed that the amount of compensation which is in deposit with the register judicial of this court is to be disbursed to the respondents in terms of the award along with the accrued interest after proper identification. It seems that এটা কার্টুন হ্যাঁ আচ্ছা Yeah. HO filed on order dated 19/7/2019. Yes, remember mine. Clear certificate of completion. Who filed this modification application?
Insurance.
One of the claimant was filed.
One of the claimant.
Claimant was died, that's why.
It seems that one of the claimants filed an application via IN number 49 of 2018 for modification of the order dated 28/6/2018 passed in the aforesaid AHO for deleting the name of respondent number 2, Mr. Subrot Mahanti, and direct the office to release the amount in favor of the remaining claimants, that is respondent number 1, 3, 4 and 5. And according this court by order dated 19/7/2019 dispose of the interim application and directed that the amount of compensation which is in deposit with the register judicial of this court may be disbursed to the claimants respondents number 1, 3, 4 and 5 in terms of the award. And accordingly, the order dated 28/6/2018 passed in the aforesaid AHO was modified. In this interim application, ground has been taken that on verification of the case record, the respondents number 1, 3 and 5, 1, 3 to 5 came to know that the award amount is not lying in deposit with the registry of this court. And therefore, the order dated 28/6/2018 actually you should have the our order to modify kariya katha 2019 the detail order pass hola 26/8/2018 ne semti kichi order pass no, we have to mention all these details so that next time we will not face any difficulty. First time ame take up kurchu mane detail ta lekhi dele se bhi bujibe to modify the lectures, the order dated 26/8/2018 to the extent that the award amount deposited with the registry may be released in favor of to recall, modify and recall order dated 28/6/2018 to the extent of inverted comma vitare, the award amount deposited with the registry may be released in favor of the claimant hyphen respondent number 1 and 3 to 5. In view of such averment made in the interim application, since it is stated that the award amount has not been deposited with the registry of the High Court, the hearing of the appellant of the HO, who is the it becomes very necessary. Stop. Issue notice to the New India Assurance Company. Requisites for issuance of notice by speed post with proof of delivery shall be filed within a week. Matter be listed on such and such date for further orders. Yes.
Item 28.
Item 28. May I audible, man?
Yes, 28. You have not filed the requisites for issuance of notice.
As it is requisite person concerned, my lord, we have taken time last week, last occasion. But this file is not available with our office. Lordship will give you another 7 days time. Our department will give this document. We'll file within 7 days. only 7 days time.
Okay,
If Mr.
Mr.
Pradhan is
Pani,
ready,
Deputy Solicitor General submits that though he was uh, supposed to file the requisites for issuance of notice to the opposite party as per order dated 3/3/2025, but the same has not been carried out and some further time be granted in that respect. Matter will be listed in the week commencing from 5th of May 2025. In the meantime, the requisites be filed. The order dated, order number 3, dated 3/3/2025, be complied with. Yes.
Hon'Ble.
Item 29.
Each file mailers substitute the legal heir of copy number 3.
You are for the
I am for the
petition.
Yes. My learning friend appearing.
I am for copy number 4, Your Lordship.
Yes. There are a number of opposite parties.
Yes, Lord.
So you have sought the interim application or
Yes.
notice has been issued on this interim application.
The earlier mailer, the interim order was passed.
No, Mr. Bose is appearing for all the opposite parties.
No, my lord. I am for copy number 4, Your Lordship.
Then who is appearing for the other opposite parties?
Others are
State
not
to
appearing.
State to Achanti. You have
State is-
also served a copy of the interim application on the state. Okay. So
1, 2, 3 and 5.
1 to 3 ଆଉ 5 ଏମାନଙ୍କ ପାଇଁ କଣ ହେଇଥିଲା? ଏ appear କରୁନାହାନ୍ତି?
Say appear corner. Only 4 is appearing and 3 is died.
Tracking report रे
3,
3 is died.
3 has
That's why
died.
file the
substitution application. Right.
Well, some defect are also there.
1 to 9, so many.
It has been repeated.
1, 9 and 20.
No, we want to know what about the because the order dated 9/11/23 indicates that about the service of notice on opposite party number 5. ହେଲା ବାକି ଯୋଉ ଅନ୍ୟ ଗୁଡାକ ରହିଗଲେ opposite party number 1, 2 and 4 ଆପଣ appear କଲେ 1, 4 ପାଇଁ
4, Your Lordship.
ତ ବାକି ରହିଲେ 1 and 2 ସେ 1, 2 ପାଇଁ notice ର position କଣ ହେଲା ଆପଣଙ୍କର?
Sufficient.
କାଇଁ କୋଉଠି ଜଣା ପଡୁନି? Tracking concerning. ଲେଖା ହେଇଛି ଅର୍ଡରରେ ଅର୍ଡର ସିଟରେ ଅଫିସ ନୋଟ ଗୁଡା ଯୋଉ ଲେଖା ହୁଏ ନା ହଁ ଏଇଠି
Notice issued to number 3 return unserved. It is ଆସିଛି appear କରିଗଲା 3. Defects number 1, 1920 not AD not received from copy number 5. In this regard, tracking report is at R. Item delivered.
item delivered ହେଇଯାଇଛି
Delivered to concern. এটা ହେଲା OP number 5.
It is received from opposite party number 1 to 6000 page 19/2023 ରେ noting ହେଇଛି non appear ସବୁ ଠିକ ଅଛି ଆଚ୍ଛା ଏଇଟା ଦେଖିଦେଲେ any objection to the
That's if I will file objection to the interim application filed by
interim application?
petitioner.
You have received a copy of the interim application.
Substitution the copy.
See, substitution.
The earlier interim order was passed on 19/4/2023.
The office note indicates that the AD has been received from opposite parties number. Office note dated लिख लेना 19/4/2023 है ना. That AD has been received from opposite parties number 1, 2, and 4. Since Mr. Bose has already entered appearance for opposite party number 4, and specific order has been passed on 9/11/2023, that the notice on the opposite party number 5 is made sufficient. It is also held that the notice issued to the opposite parties number 1 and 2 are also sufficient. Stop. None appears for opposite party number 1 and 2. It is okay. IA number so and so. There is an application for substitution of the legal representative of opposite party number 3. Ismail Sahaji. Copy of the interim application has already been served on the Learned Counsel for the state, so also Learned Counsel for the opposite party number 4. The Learned Counsel for the opposite party number 4 seeks some time to file objection to the interim application. So we are listing it on we commencing from 21st. In the meantime, you file. Matter will be listed on 22nd of April 2025. Objection, if any, to the interim application be filed by the opposite party number 4 in the meantime.
Can you see the 19/4/23 order? There is a status quo order earlier. And that extends we file the extension of status quo order.
9/11 is a continuous.
19/4/2023.
No, 19/11.
Status quo order be maintained till next date of hearing.
Next
date hearing होची 10 May 2023. तापरे आपनकर 9/11/2023 रे एक्सटेंशन हेनी.
10 रे मेले तो सीधा लिस्ट ही पहला.
कोनटा
लिस्ट ही
9/11/2023 रे पूरा कोर्ट रे लिस्टिंग हेकिने ऑर्डर टा पास हेची. तापरे आपनकर प्रथम ऑर्डर टा होची 19/4/2023 जो थरे की स्टेटस को ऑर्डर पास हला. But thereafter the matter was listed on 2 dates, that is on 9/11/23 and 27/3/2023. There was no prayer made to continue that status quo order. So now what application has been filed?
Extension of interim order set at 19/4/2023.
You also take instruction on this. Maybe that there is no status quo or something might have happened. Who knows? IN number 5323 of 2025. This is an application for extension of interim order dated 19/4/2023. It appears that
copy
while
not my lord.
the copy let a copy of the interim application be served on the Learned Counsel for the state. It appears that while issuing notice to the opposite parties number 1 to 5, the matter was directed to be listed on 10th May 2023, and the status quo is directed to be maintained till next date of hearing. However, thereafter the matter was listed on 9/11/2023, also on 27/3/2025, and there was no prayer made by the Learned Counsel for the petitioner for continuance of the status quo order. Such a scenario the learned counsel for the state submits that he may be supplied with a copy of the interim application in order to obtain instruction in the matter. Put up this matter. What will date is given? Huh? Say date. Yes.
Date.
well, अपना 22 ना 23 के बोल रखा 22 तारीख के रहा 22nd 4/2025 AI वो status पर दीटा जगह आई है अस्सी है ना yes
Progress. Item 30.
Wait, please, Manoj. Formal amendment has been filed, Manoj, IA number 286 of 2025. Now, there are two writ petitions which have been filed. Against Manoj, approval was sought for dismissing an workman on the on various grounds. Approval was not granted by the tribunal. So that order was challenged by my learned friend Sale, the first writ. Second writ, we have challenged it because.
Have you received a copy? You are appearing for the.
No, opposite party 1 and 2 on behalf of.
Have you received a copy of the interim application?
Yes, my lord. We have received.
Any
we have
objection
filed
to
a
that?
reply as well.
We have formal.
All right, IN number 286 of 2025. There is an application for amendment. Copy of the interim application has already been served on the learned counsel for the opposite parties. Number कितने number अपनो 1 and 2. How many opposite parties are there?
Two only.
Two. Opposite parties for them. Who seek some time to file objection.
No, we have filed objection.
You have already filed.
Already filed.
Where is that objection?
Objection.
So anything serious?
Reply affidavit.
It's formal.
This is reply affidavit.
No, the young counsel should say.
My lord, the amendment may be allowed without.
That, all right.
Without.
No, we will not note your concession. That's all right. You should say that.
Just one.
Do the reply.
I was in fact little hesitant to stand today because of my learned young friend is there.
Reply has been filed to the interim application after hearing the learned for the parties and going through the averments taken in the interim application, so also the reply. We are inclined to allow the prayer made in the interim application. Now the proposed amendment shall form a part of the writ petition. Let a consolidated writ petition be filed within by next week. By next week, serving a copy on the learned counsel for the opposite party. Yes.
Wait, my lord, some time may be granted for filing of counter.
Additional counter.
Just let the consolidated writ petition, you receive it, then we'll take up this.
Oblige.
Item 31.
Item 31 is delay in filing the review in 9 days.
What is the stamp reporter has saying that there is 9 days delay? Yes. Who is
Notice has not been issued.
notice not issued? Who are the opposite parties?
My lord, the opposite parties are the original, the persons who are in unauthorized occupation of the land.
No. So far as we opposite party number 2 is concerned, that is this Union of India is there. So have you served a copy? Mr. Pari,
There is a copy they will
give the copy. And so far as 3, 4,
and
5 is concerned, you have received the copy.
Yes, my lord. The notice about 6, 7, 8.
6, 7, 8.
6, 7, 8, and also number 1,
Mr. Pari.
Purchian Gupta. Mr. Pari, this is an application for condonation of delay, and notice has to be issued. 9 days delay has been pointed out by the stamp reporter, the registry. So notice has to go, and you are appearing for the Union of India, who is the opposite party number 2. So let's do IN number so and so. There is an application for condonation of delay. The stamp reporter has pointed out that there is 9 days delay in filing this review petition. Issue notice on the question of limitation land counsel for the opposite party number 2 accepts notice, Mr. Swanso accept notice for opposite party number 2. Let a copy of the interim application be served on the land counsel for the Union of India. So far as opposite party number 3, 4, and 5 are concerned, land counsel for the state accepts notice. Copy you have already received.
Yes, sir.
The land counsel for
Let
the
me
state.
copy may be served to our office.
Let a copy so in the it has your number 2 file. Copy has already been received by the land counsel for the state. So far as the private opposite parties are concerned, that is opposite party number 1, 6, 7, and 8 are concerned. Requisites for issuance of notice by speed post with proof of delivery shall be filed by next week. Matter be listed on such and such date. Objection, if any, to the interim application be filed in the meantime.
Can I be permitted to make a mention?
Yes, Mr. Panda.
For an assignment of my Lord the Chief Justice, I have filed a WPCRL 34 of 2025, wherein I have challenged an illegal order passed under Section 18(1) of the Prevention of Immoral Traffic Act 1956 by the SDM Puri. My hotel has been sealed for 3 years, something which he cannot do, Mills. Taken up tomorrow.
We file the memo, it will be you have 3 years.
Yes, memo is there. I am filing physical memo. If your lordship
Okay. Then you keep the memo and show it in my chamber.
Item 6, your lordship can adjourn. Pray for adjourn.
Let the matter reaches where you mentioning orders matter. Yeah.
Well, this is special mentioning matter, my lord. This is civil bench matter. I understand, my lord, this bench is criminal bench matter. But the demolition is to be taken place tomorrow, my friend. The notice was issued by the land acquisition officer and it was issued on 5th. But the demolition is on 11th, my lord. Today, my lord, inadvertently the matter was listed before court number 6, single bench. So, state who must delist kari ki tango mention kari ki anichi.
Give the memo, we'll see that.
Yes, sir.
Yes, yes.
If it can be taken up today, my lord.
Yes.
Today.
The last item of this question.
Yes, next. Call the matter.
Tomorrow is the demolition.
Supplemental list, item number 1.
May I please, Your Lordship? Lord, I'm on VC, my lords. It's a live conviction case. 6% my lord convicted for life, that is at page 57, my lord, sentence. Paragraph 4.
Admit for the trial court.
May I pray another thing, my lord?
Yes.
In the first paragraph, the learned court below has held that the convict Singana Kalaka, that is petitioner number 1, Dhanyar Taiko, that is petitioner number 4, are extreme old age, whereas convict Shukru Kalka is a chronic kidney related disease problem.
I'll file interim application for bail, we'll see that.
My lord.
Next.
Item 2.
I allow it.
May I please, my lord? Offense under section 302, 506, IPC,
reduce imprisonment life and fine 10,000, my lord.
Okay, admit.
Noblesse, my lord.
Call for the trial court report, interim application for bail and sterilization of fine to be considered after receipt of the trial court report. Deposition copies to be supplied. No? Yes.
Item 3.
The lordship was pleased to call for the custody certificate and criminal antecedent e-filing. The date that is 25/3/2025. The State Council was directed to obtain the instructions.
Yes. You want more time? You are Mr. What is your good name? Mr. Jayant Khandayat, Land Council, appealing for the state 6 or more time to obtain instruction to produce the custody certificate of the appellant. So also to obtain instruction regarding criminal and against the appellant. Put of this matter, the commencing from 21st. All right. Published.
Item 4.
Ma'am, under the appellant is custody since 10 January 2021, my lord, for commencing offense under section 376 2N, 376 3, 294, 506, 34 IPC, related section 6 of the Poxo Act, my lord.
That is the number 5. That one business person is there in that for engagement of the counsel, Mr. Dikko Patram.
Just a minute.
Clarity.
Reason for engagement of Mr. D.K. Patra. Then Mrs. So and so file wakalatnama without taking the consent. Acha. D.K. Patra onare aschi engagement kuriya pai.
D.K. Patra is my associate lawyer.
He has signed the wakalatnama. Okay. So aguru kaha na re tila. You amicus curiae appointment. So all right. Peruse the prisoner's petition at flag D for engagement of Mr. D.K. Patra as his counsel. Mr. Patra along with Mr. Bisujit Naik and others have filed wakalatnama on behalf of the appellant. The pair made in the prisoner's petition is accepted, so also the wakalatnama. The name of the learned amicus curiae, S.K.Sahoo shall not be reflected in the cause list henceforth. Yes, what about the interim applications?
No, that I have filed an application for bail.
That is IN number 248.
No.
So, how many years he is in custody?
He is in custody since 22/5/2021.
5 वर्ष भी नहीं, 4 वर्ष. What is the case?
Case case of charge under section 494, 498 and 302. But convicted under section 302 and sentenced.
You are the husband?
And the husband they are saying that he is the husband. Yes, sir. But the marriage has not been done. The father with the informant here the PW1, sorry, the PW10. So that is the section 490, 494 has not been.
No, it's all right. You have been acquitted under 498
and 494.
494. But so far as 302 is concerned, what are the evidence on record against you?
There is no eyewitness to the occurrence. And the Lord's trial court will see paragraph 14.
What is the cause of death as per the
cause of death?
Who is the doctor who conducted PM?
Doctor is PW11. 11.
And what is his opinion regarding cause of death? Ultimatum
hemorrhagic shock caused by homicidal multiple head injury.
Achha.
Head injury. She was pregnant.
Achha, she was pregnant also.
Item 6.
Yes, item number 6.
Not after vacancy.
Mr. Samantrayal and counsel appearing for the appellant seeks for an adjournment uh, to after ensuing summer vacation. This matter. Date the Yes.
Item 7.
Let in item 7, today I am serving the copy of the depositions, madam.
All right. IA number to answer this is an application for bail. Mr. Roy and counsel appearing for the appellant submits that during course of the day you will supply the deposition copies to the London Council for the state.
My clerk is there, madam.
Already supplied, sir. He has already supplied so answering today. Land Council for the state seeks some time to go through the same. List this matter in the week commencing from 21st April 2025.
Item 8.
For consideration of the bail application. Yeah.
By the last orders, the TCR has already been called for and appeal has been admitted. Applications for bail, we were directed to file fresh applications because of certain errors in the prayer manual that we have complied with. And in the meantime, the paperwork is also there, but my bail application was to be considered for the first time alone.
Yeah. So you have received the copy of the paper book.
Yes, ma'am.
Okay. So what is the offense for which you are found guilty?
My lord, 302, that is 34 IPC.
Okay. How many persons are there in
My
the
lord, 2 persons.
2 persons.
The lordship.
No, but the appellant is one.
Appellant is one. My lord, I have been instructed for one counselor. For one.
No, the 2 persons face trial.
My lord,
and both of them are also found guilty. And you have no instruction whether that other person has
filed an appeal.
Filed an appeal or not.
My lord, I was checking the website and I did not find any named person of the other, my father filing an appeal.
That means so far no appeal is there.
Your lordship.
Okay. Now, what is the prosecution case?
The son, the father is the other accused.
He is
Father
the son and
son,
father.
both. Son
No,
and
no.
father, both are there.
Son of Perilal Sabar. The other accused is
Parallel
the
cover is
judgment, of
second
course, is dated
Parallel.
7th of 2024.
Only.
So
Yes,
he
yes.
may file appeal. So you are not. Now, what is the prosecution case?
Well,
Son
the
and
prosecution's case is that on 10th of December 2018,
Please come to paragraph number 2.
your lordship, is that the informant Dukhi Varia has alleged that on 10th December 2018 at about 4:30 p.m., the accused persons, due to previous enmity, abused her husband Mukunda in obscene words, saying,
Leave it. And then
in front of the village club. Both the accused persons threatened to kill them. Accused Parilal Sabar held the accused and accused Puran Sabar dealt 4 mehra blows on the head of the deceased, due to which he fell down and sustained bleeding injuries. When S.K.Sahoo intervened, the accused persons ran away from the spot. Seeing the condition of her husband, she was senseless. The villagers shifted her husband to hospital. Then her husband was referred to Burla Hospital. Lakshmi Baria and Subhadra Baria had witnessed the occurrence. Basing on her FIR,
who are the eyewitnesses?
my lord, according to the prosecution's case of the informant,
The wife.
Just a minute.
my lord, according to the informant, my lord, PW13 is that S.K.Sahoo who comes in at that spot your lordship just read. Then it is PW7 Lakshmi Baria and PW8 Subhadra Baria.
These are the 3 FIR named eyewitnesses.
Your lordship.
Okay. And they have not supported the
They have
prosecution.
done hostile, your lordship.
Okay. The person who has not been named in the FIR
Nobody.
as an eyewitness, he has deposed as eyewitness.
My lord, the informant is the wife who says that I have seen the occurrence.
Just a minute. Now let us see. Come to the FIR.
Your lordship.
This Dukhi Baria has been examined as PW
12. Who's the informant?
Okay. She herself states in that FIR that she is an eyewitness to the occurrence.
Yes.
Right. So apart from
Informed.
her,
Yes.
she has stated that the other persons had also seen
The occurrence.
they have not supported the prosecution case.
Yes.
And this version which she has stated in the FIR is also her version as a PW12.
Your Lordship.
So, and what about the doctor who conducted PM?
PW20, Your Lordship.
So, all the injuries, external injuries as it appears,
the
those are on the head,
head only.
Head.
right? Frontal, right frontal, left temporal, then
My Lord, frontal Your Lordship will mark because she categorically deposes in the testimony that the injuries are to the backside and there are more than 4 and 5. Whereas as per the postmortem report, there are 3 injuries. And the doctor also categorically states that these are possible by fall. That is there, Your Lordship, may kindly say.
due to application of hard and blunt
Yes.
trauma. And this wooden plank which was used according to the prosecution was also sent to the doctor and it has been marked as MO1.
Well, none of the witnesses who were witness to this seizure of this have been ever shown that. My Lord, they have never been confronted that material object in the court and they say that it is not relevant.
Injuries are possible detected on the swan shoe can be possible by the said weapon. So doctor has stated that and no, let us say that it was not shown to the most important witness is PW12.
My Lord.
But
except the doctor, it was not shown to anybody.
No, the IO has stated about its recovery from the spot or at the instance of the appellant at some other place.
My Lord, would kindly have that PW21. On 30/12/2018, I sent requisition having query over weapon of offense exhibit P19, already marked exhibit P19 in my signature.
ଲାଠିଟା ସ୍ପଟରେ ପଡିଥିଲା ହଁ ସେଠି ଲେଖୁଛନ୍ତି I visited the spot, examined the other witnesses and seized the weapon of offense one wooden lying there. That means spot ରୁ seize କଲା ହଁ
My Lord, may I just pause here for a moment?
Yes.
My Lord, the occurrence is of 18th and the FIR has been registered on, sorry, the occurrence is of 10th and the FIR has been registered on 18th. So this is after 11, it is after more than 9 days, Your Lordship. Your Lordship may kindly mark that date.
What she stated about the delay in disclosure or lodging the FIR, the husband died at the spot.
No, my lord. My lord, she was referred to Burla.
Okay.
And thereafter, after treatment for more than 8 days, 9 days, thereafter the husband died and then she brought her back. Never during her stay at Burla does she ever make any complaint to the Burla police station or the police present there. That is a deposition, your lordship. Paragraph 10. Your lordship can kindly have cross-examination para 8 and 9, my lord. My lord, I would rely on this to impeach the witness of PW12 for the fact that I state that she was not an eyewitness, but she came to the spot after hearing the halla as per her own deposition, my lord. May I kindly read that, your lordship?
In that respect, paragraph 15 and 16, he has stated. He has seen everything in the cross-examination.
କଣ
Cross-examination.
Paragraph 8 and 9 of the cross-examination. if you
We
look-
have seen it.
Yes, and therefore, my lord, and the other witnesses say that the wife was reached later than that of the other petitioners who have come to this court and say that they have never ever seen any
You
assault.
see, all those things are to be appreciated when the final hearing is
I
taken up. We cannot at this stage analyze the evidence and
About
appreciate that whether his evidence or evidence will be acceptable or not, whether she is a truthful witness or not.
About
So if prima facie what is there in the evidence which is to be seen, witness has stated that she has dealt, you have dealt 4 to 5 blows on the head of the deceased, and he fell down and shifted to the hospital, and delay is to be that whether the delay can be stated to have been satisfactorily explained because she was accompanying the husband from hospital to hospital and was there with him, must be taking care of all, and after death she might have lost the FIR. So this is what appears from her evidence.
Maybe after the
Ultimately, the court might be whosoever will he might be satisfied that yes, this explanation is satisfactory. କାରଣ ସେ FIR ରେ ମଧ୍ୟ ହଉଛି ଯେ ମୁଁ ଚେତା ଆସିବାରୁ ଦେଖିଲି ଆମର ଗାଁ ଲୋକ ମୋର ସ୍ୱାମୀକୁ ଗୋଟିଏ ଗାଡିରେ ପଦ୍ମପୁର ଡାକ୍ତରଖାନାକୁ ନେଲେ, ତାଙ୍କ ଅବସ୍ଥା ଆହୁରି ଖରାପ ହେବାରୁ ଡାକ୍ତର ବୁର୍ଲା ଡାକ୍ତରଖାନାକୁ ପଠାଇଲେ। ବୁର୍ଲାରେ ଚିକିତ୍ସିତ ହେଉଥିବା ଅବସ୍ଥାରେ ଆଜି 18/12/2018 ସକାଳେ ମୋର ସ୍ୱାମୀ ମୃତ୍ୟୁବରଣ କଲେ।
For the death of the person he has
10 ତାରିଖରୁ 18 ତାରିଖ ପର୍ଯ୍ୟନ୍ତ ଇଏ ତାର ଚେତା ଆସିବା ପରଠୁ ସ୍ୱାମୀ ସାଙ୍ଗରେ ବୁଲୁଛି ପଦ୍ମପୁର ତାପରେ ବୁର୍ଲା ତାପରେ ମରିବା ପରେ ଏତଲାଟା ଦେଇଛି। ତେଣୁ whether it will be acceptable or not, that is to be seen at that time.
That is why, my lord, I am only requesting your lordship if it can have a glance at PW9, the witnesses who categorically state that they have come before the wife to the spot. So, my lord, even the person at whose house she was, Lakshmi Bariya, she does not support the prosecution.
They have not supported the prosecution case. So, so all those witnesses on whom you are placing reliance, they have turned hostile.
Turned hostile, your lordship.
So, the only one witness and is the wife of the any kind of previous dispute with you,
yes, my lord,
to implicate you.
Yes. That is there, your lordship.
What is that? You have taken a plea that by putting a suggestion to her that your husband sustained injury as he fell down in drunken state and accused persons have not assaulted in paragraph number 18. That is your suggestion.
My lord.
That's
Tularam, the person who is not supported,
my lord,
in his cross-examination, it is brought, and he is saying that it is not a fact that I had not seen accused Puran holding a mera was going to assault the deceased, and not a fact that I am stating falsehood.
My lord, would kindly see the deposition as to why he was turned hostile. The prosecution turns him hostile, my lord.
Yes.
My lord could see Tularam is PW9, your lordship.
Yeah.
Yes, my lord would see. My lord, the prosecution decides that this witness is hostile.
Exactly.
Yes.
But what was there to bring it on cross-examination?
My lord, Puran was holding a mera and was going to assault.
Yes.
Yes.
Then he went away. He says
Then
that I left I ran away to my home.
My lord, how would he know that who is going to assault?
No, no, no.
I put a question to
He
myself.
said, no. Up to that level, he has seen.
Yes,
that
sir.
is there.
My lord.
Wife is along with the deceased. Wife is along with the deceased. That is there.
My lord.
That's all.
For what was the need for the prosecution to declare him hostile?
No, you forget about him.
My lord.
Only to the extent in the cross-examination you are bringing, not in the examination in chief.
One would kindly read paragraph 7 of the cross-examination of PW9. After the occurrence, I went to the spot and I had not seen the occurrence.
Exactly. Occurrence means the assault he has not seen.
Yes.
That is
So
correct.
then he comes.
But by then he was there. No,
Your Lordship, then he says that I come to the spot. At that point of time, there are no villagers, and only thereafter somebody else has come up, that is including the wife and others. And this is also the deposition of PW 13.
So the presence of wife cannot be
is being
disputed.
Is being disputed.
Why? Who said?
My Lord, paragraph 7 and paragraph, Your Lordship.
Of whom? He is a villager. He is
Yes.
not a villager.
But he is a villager.
Who?
200 meters away.
Wife is not a villager, sir. No villager was present.
My Lord, kindly have them PW.
Is there any question to the wife was present or not? No.
My Lord, PW 13, Your Lordship.
13.
Your Lordship.
Yes.
Cross-examination, paragraph 5, Your Lordship.
He has also not supported anyway.
My Lord, this is that person who the wife names in the affair that this person comes to the spot and thereafter the present appellant and his father run away from the spot. So paragraph 5 of the cross lordship will see, after my arrival at the spot, the wife of the deceased named Dukhibari.
No, because wife got senseless, no? It is there.
No, my Lord, she categorically states this, that I come to this spot and only after me, the wife and the other persons named in the affair come to this spot. This is the categorical submission, my Lord.
All right. The learning counsel for the petitioner and counsel for the state. The learning counsel for the petitioner submits that the petitioner is in judicial custody since 27/12/2018. And in the first information lost by PW12, Srimati Dukhi Baria, the widow of the deceased, Makunda Bariha, it is stated that PWs 7, 8, and 13 are the eyewitnesses to the occurrence, but none of them have supported the prosecution case during trial. The Land Council further submits that though the occurrence in question stated to have taken place on 10/12/2018, but the first information report has been lost on 18/12/2018, and no satisfactory explanation has been offered by the prosecution in that respect. The Land Council further submits that there are other witnesses who have not supported the prosecution case, have stated that PW12 arrived at the spot at a later point of time, and therefore the presence of PW12 at the scene of occurrence at the relevant time is a doubtful feature. He submits that the doctor has Dr. PW20 has stated that though the cause of death was on account of head injury sustained by the deceased and its complication, but in the cross-examination, he has stated that the injuries present over the dead body of the deceased were possible if a person falls strongly on the rough surface. And since there is no chance of early hearing of the criminal appeal and balance of convenience is in favor of the petitioner, the bail application may be favorably considered. Land Counsel for the state, on the other hand, opposed the prayer for bail and stated that PW12, being the wife of the deceased, has specifically stated that the appellant dealt 4 to 5 blows on the head of the deceased, for which the deceased fell down unconscious, sustaining bleeding injuries on the head. And thereafter, he was taken first to Padmampur Hospital and then to Burla Hospital, where, while undergoing treatment, the deceased died. The Land Council submits that in view of such statement made by PW12, it can be said that there is satisfactory explanation regarding the delay in lodging the FIR. Moreover, PW20, the doctor, has stated on examining the wooden plank which was seized at the spot and marked as MO1 that the injury sustained by the deceased could be possible by MO1. Considering the submission made by the Learning Council for the respective parties, the nature of evidence adduced by the solitary eyewitness bracket PW12 and the evidence of the doctor PW20, we are not inclined to release the petitioner on bail. Accordingly, the bail application rejected. Stay relation of fine.
Item 9.
Permitted to collect a copy of the paper book.
Paper book is prepared.
Paper book is already prepared.
The Learning Council for the appellant submits that since the paper book has already been prepared, he may be supplied with a copy of the same. Let the registry supply the copy of the paper book to the Learning Council for the appellant. You have received the paper book?
Yes, sir.
Okay. Learning Council for the state submit that he has received the copy of the paper. Yes.
Gratefully lodged.
Item 9.
9 गला परा?
8 गला.
ना ना 8 टा तो गला नहीं आगे वे 9 टा पेपर बुक मागिरा ना
No, it's 8. 8.
वो अच्छा 8 रे में
Total it is.
से पर उसका पर 9
Also bail rejected.
yes 9
Last occasion 3 bail was rejected. The name appeared in the paper with outside.
we have rejected your bail application on 3/3/25
Yes.
तो वर्तमान कौन पे आछी वो स्टे रियलाइजेशन ऑफ फाइन
Noting में kindly.
noting और noting कौन आछी report of the land and register judicial at flag G में kindly be seen कौन आछी auditor is company who was the auditor going to the paper book we found that while recording the evidence of the victim as P1, the name of the victim has not been reflected in the deposition sheet or in the judgment by the Learning Trial Court. However, Mr. B. Tudu, while preparing the paper book, has mentioned the name of the victim in the paper. In view of the decision of the Honorable Supreme Court not to mention the name of the so an explanation be called for on so on.
Explanation to this. Acknowledge the mention of the victim's name was an inadvertent error and I did regret the oversight.
Okay.
Court will say this. Court then will say this.
In view of the order dated P3/2025, it appears that the registered judicial called for explanation from E to do. Vidulal to do ASO type and paperwork section, Oloka Swine ASO type and paperwork section, and Binapani Sasmal copyist type and paperwork section. And all of them have stated no. While Mr. Tudu stated that he was not aware about the fact that the name and identity of the victim in case involving sexual offenses shall not be mentioned anywhere.
Lordship, the 1 year, the date of that 1 year started is 2 year. We have filed an interim application in the basis that the present applicant was not present while his mother had died. So the 1 year shroud ceremony is today itself.
So what can be done? And you have stated perhaps that କିଛି ହଉନି ବୋଲି କଣ କିଛି ଶ୍ରାଦ୍ଧରେ କିଛି ହଉନି.
Yes, your Lordship, that's something that the Puji ka କିଛି ହଉନି, but nobody is there in the family actually.
କିଛି ଶ୍ରାଦ୍ଧ ପାଇଁ ଆପଣ ଗୋଟେ ସ୍ପେସିଫିକ ପର୍ପସ ପାଇଁ ଯିବାକୁ ଚାହୁଁଛନ୍ତି. ଆପଣଙ୍କର ମାଙ୍କ ଶ୍ରାଦ୍ଧ ହଉଛି ଆଜି, ଆପଣ ନିଜେ ଲେଖୁଛନ୍ତି ଯେ ସେମିତି କିଛି ହଉନି ଘରେ, ହଉନି ତ ହଉନି ଆଉ ଏଇଟା ଏଇ ଆପ୍ଲିକେସନ ଟା କାହିଁ ଆପଣଙ୍କର ଅନ୍ୟ ଆପ୍ଲିକେସନ ଫାଇଲ କରନ୍ତୁ, ଲେଖନ୍ତୁ IN number so and so. This is an application for interim bail on the ground that to perform the first year Shraddha ceremony of the deceased mother. The learning counsel for the state
has received instruction from the IIC Uda Nagari Police Station dated 10/4/2025, wherein it is mentioned that the first death anniversary of the mother of the petitioner is being observed today, that is on 10/4/2025, native village Hantapada. Since it is the council submission that no such formal ceremony is to be done on today, we are not inclined to grant bail to the petitioner. Accordingly, interim application stands rejected. Yes, this is taken on record.
Item 11.
Lord, I have filed two applications. One is bail and another is stay relation of file.
Have you supplied the deposition copies?
Paper book is there, madam.
Paper book is there. So,
And for some item, in criminal law.
ठीक है, ठीक है. The conviction is under section
302 and 34 of IPC.
and it is a case based on direct evidence or circumstantial evidence.
Circumstantial evidence.
Circumstantial evidence.
Yes, Lord.
Okay. Name of the deceased is Kesava Patra.
Kesava Patra.
So, how many persons face trial? Two.
Two persons.
Okay. So, you come to paragraph number 2, let us see,
Yes, Lord.
of the judgment.
Yes, Lord.
Please proceed.
The case of the prosecution in brief is that on 23/9/2020 in the evening, one Kesava Patra, hereinafter referred as the deceased, had been towards the Panchayat office of his village Bhurtigarh. There he had some quarrel with the accused Ranjan Patra, who gave a blow by means of a thenga, as a result of which he sustained bleeding injury on his head and fell down. Kesava, in injured and bleeding condition, was shifted to his house by Panchayat office peon and his wife. On being asked by his parents, he disclosed that the accused Ranjan caused his head injury. There was a call for ambulance vehicle which did not arrive, and on the next day, while the deceased was being taken to hospital by means of an auto rickshaw, he expired on the way. The father of the deceased filed a written
So,
report.
dying declaration is there. Oral dying
declaration.
Before whom?
Before 3 and
Parents.
Before 3 and
PW3
my lord.
and
3, 4 and 5.
3, 4, 5, 6 and 14.
नहीं 3, 4, 5 है तो
Yes.
6, 14 भी अच्छे हैं
ना 6 रे
तो फिर present ଥିଲେ।
हाँ immediate post occurrence।
अच्छा
Yes, sir.
ठीक ଅଛି PW3 कौन କହୁଛି ଆସନ୍ତୁ
Yes, sir.
ଜଣଙ୍କର ପଢି ଦିଅନ୍ତୁ ଏକା ପ୍ରକାର ନା ଭେରିଏସନ କିଛି
Variation
ଟିକେ ଅଛି PW5 କହିଛି ଟିକେ ଆଉ ଟିକେ ସ୍ପେସିଫିକ କହିଛି
ନାଇଁ କଣ ନେମ ରେ ଭେରିଏସନ ଅଛି କିଏ ମାରିଲା
general allegation ଟା ଦିଟା ଦି ଜଣ ପାଖରେ general
on
ଆଉ
being
ଗୋଟେ
asked
specific.
said
ରୁହନ୍ତୁ 3 କୁ ପଳେଇ ଆସନ୍ତୁ
ମାଲା
He is the father of the deceased. I am the informant. The deceased is my son. Both the accused persons standing in the dock. My deceased son had gone to Panchayat office located in our village. One Rukmani Patra of our village and her husband heard shout of my son, and seeing him sustaining bleeding injury brought him to my house. I found my son sustained bleeding injury at his head, and he had also sustained injury at his waist. On being asked, he said that the accused Ranjan and Shankar assaulted him by means of a thenga. He lost his. We shifted him to hospital by an auto rickshaw, but on the way to hospital, he succumbed to his injuries. Then we proceeded to Sikarpura police outpost, where the police asked us to Nanda.
district oral dying declaration That apart, my
No, this PW3 is the informant.
Informant, father of the
Right. And in the FIR, he has stated that the disclosure was made only in respect of Ranjan Patra. FIR re
କେବଳ ରଞ୍ଜନ
dying
ପାତ୍ର।
declaration ରେ ଅଛି Ranjan Patra.
Yes.
So
But
ये
PW5
subsequently preached.
kindly have a glance to PW5.
PW5 कौन कोई?
Wife of the deceased.
हाँ.
My deceased husband.
What this is what told by my husband when he arrived at our house, being brought. Sorry, my deceased husband had gone to ask Panchayat office. There was assault by the accused to Ranjan by means of thenga, and the other accused, namely Shankar Patra, assaulted him by dealing kick and fist blows.
That is what told by my husband when he arrived at the Swanch.
My lord.
All these things, but fact remains that at the very first instance, these are all family members, na?
Yes, Lord.
ये जो PW3-4 तो घर को आसिला घरे समस्त सामने डिस्क्लोज कला तापरे गले एफआईआर देले एफआईआर रे डाइंग डिक्लेरेशन रे जणे अक्यूज्ड ना अछि
My lord, that about the conduct of the accused. Can have a glance to PW7.
Yeah.
I know that the deceased, his father, informant, and both the accused person. The alleged incident was
कोटा पुडचंदी
PW7.
ठीक है
सी एमाने समस्त सेदिन चिकन किणी रोसई करी खाइ बोली प्लानिंग करथले रोसई सल्ला परे दी जण अक्यूज्ड आसिले ना I accompanied the accused persons to purchase chicken. We brought chicken from the shop of owner Gunapatra. The accused person told me to prepare chicken and went out. I cooked chicken and kept for them. I did not meet them in the evening. But on the following morning, I heard about death of the deceased man.
चिकन को वास्तव में
The owner of the chicken shop.
It's all right. It's a no. The main evidence is the dying declaration.
Yes.
So question is that whether it is the involvement of or it is the involvement of one and subsequently it is developed. So when PW one, the informant lost the FIR.
PW3 man.
PW3. The informant lost the FIR and categorically stated in the FIR that
PW6 also.
तापरे मोर पुओ भरत राम पात्र
Bhagat Ram, that Panchayat office peon.
हाँ वो तार स्त्री रुक्मिणी पात्र
is PW6. He is the immediate
भरत राम केते भरत राम के
Bhagat Ram PW14.
अच्छा PW14 और PW6 एमाने केशव को आनी मो घरे छाड़िले सेती बेले मो पुओर मुंडरू रक्त बाहरुथिला मु ताकू पचारिबारु से कहिला कि रंजन पात्र ठेंगारे मो मुंड को बहुत पिटिछि जहा फल रे मुंड फाटी रक्त बाहरुछि सेही राति रे केशव पात्र पुहरी पुहरी सोईथिला आज सकाळे ताकू डाक्तरखाना आनिबु बोली 108 को फोन करिथिलु किंतु आसिला नाही परे गोटिए ऑटो भड़ा करी आनिलु रामपुर थाना को आनिलु बाटरे तार मृत्यु हो जाइथिला एवं डाक्टर देखि मृत्यु बोली घोषणा कले मोर पुओ रंजन पात्र मारी थिबारु तार मृत्यु स्पेसिफिक सो डाइंग डिक्लेरेशन एवं डाइंग डिक्लेरेशन रे रंजन पात्र ये एंड
evidence
that is the reason why the FIR was also lodged against only Ranjan Patra. Now Ranjan Patra pai ke
I am for the Ranjan Patra.
So you have no case. So
PW9 and medical.
PW9 is doctor.
Medical. He stated that if proper medical treatment was immediate medical
that you
108 को फोन कले आसिलानी तापर से रहिले सकाळे ऑटो नहीं गले मरि गला आउ से को गां भीतर रोकंती जोठी 108 मोबा ये रेस्पॉन्स करनी आपण कहबे शीघ्र नहीं जाइतले ताकू नहीं भुवनेश्वर रे को बड़ हॉस्पिटल
but nature of death, cause of death could not be ascertained.
अच्छी अपन रूम तो आप किस दिन परे करिवे JCRL number 90
More
of
than 4 years.
2024. There is an application for bail. Mr. Samant Roy, Land Counsel appearing for the petitioner, submits that the petitioner is in judicial custody since 2/10/2020. There are no eyewitnesses to the occurrence, and in the first information report lodged by PW3, it is specifically stated that when PW6 and PW14 brought the deceased in an injured condition to the house, on query being made by PW3, the deceased disclosed that accused Ranjan Patra assaulted him by a lathi on his head repeatedly, and that is the reason why, and the death took place on and that the death took place on account of assault by accused Ranjan Patra, and that is the reason why the first information report was lodged only against Ranjan Patra. It is further argued by the Learned Counsel that at the trial stage, the witnesses have developed their case and implicated the present petitioner, Shankar Patra, to be one of the assailants basing on the dying declaration of the deceased. Land Counsel submits that the implication of the petitioner as an assailant of the deceased in the dying declaration is an afterthought story, and the petitioner has good chances of success in the appeal, and balance of convenience is in favor, and there is no chance of early hearing of the appeal, and therefore the bail application may be favorably considered. Learned Counsel for the state oppose the prayer for bail and place the evidence of PW3, 4, and PW5, the witnesses to the dying declaration. So also PW, with the doctor,
PW9.
PW9, the doctor who conducted post-mortem examination and
PW7, the
opined that the injuries noticed on the occipital region of the deceased can cause the death, and further opined on examining the wooden lathi that the injuries are possible that the blow produced by such lathi can cause death of the person. Considering the submission made by the Learned Counsel for the respective parties, the fact that the informant at the first instance, at the time of lodging the first information report, has not implicated the present petitioner as an assailant of the deceased basing on the dying declaration, and the case has also not been registered against the petitioner for the taking into account the period of detention of the petitioner in judicial custody, we are inclined to release the petitioner on bail. So it is allowed stay realization of fine. So far as the second item is concerned, learned counsel for the petitioner submitted that the case is based on the dying declaration of 3 witnesses, that is PW 3, 4, and 5. However, the doctor bracket PW 9 has noticed one injury on the head, which is a lacerated wound, and therefore the petitioner can be stated to have dealt a single blow on the vital part of the body, which has resulted in the death of the deceased, and therefore in the factual scenario, the bail application may be favorably considered. Learned counsel for the state oppose the prayer for bail and place the evidence of PWs 3, 4, and 5. He further submits that name of the petitioner is also mentioned in the FIR as the assailant of the deceased in the dying declaration in the deceased dying declaration. Considering the submission made by the learned counsel for the respective parties, the evidence relating to the dying declaration, so also the post-mortem report finding, at this stage, we are not inclined to release the petitioner on bail, stands rejected. Yes.
Item 12.
Lordship, in this case, kindly have a class order dated 7/11/2024, Lordship.
Yes, health condition. अच्छा, this is that 75 years. अच्छा, ये जो आशिफिला से Lion Trial Court has lost sight of the fact that the accused was mentally unsound. In support of the same, he has placed that there is absolute no.
An accused is not 75. Accused killed a person who is 75 years. Accused claiming him as
accused is 35
mad.
years.
Acha, acha.
Accused is 35 years.
35.
How much prosecutor shall take them whether there is anybody in the family to take care of the applicant. से पॉइंट आउट करथिले सेइथाय लिखि जंदी
Then here at before this honorable court, the counsel for the petitioner raised that the petitioner is unsound.
Court file is oda.
No, Lordship, as per direction of the honorable court, the state council obtained instruction. That is the order, Lordship.
28/8/2024 लिखा है जी learned counsel for the appellant taken through the judgment and deposition of the prosecution witnesses and express that perhaps the learned trial court has lost sight of the fact that accused was mentally unsound. ये जिनसे कौन सी evidence रे आछि ना judgment रे लिखा है जी आपण जो submission कले सेथि पई court order कले जे state council को जे सी जदि bail ले भी जीवो in the present health condition, whether there is anybody to take care of her. এটা হচ্ছে order dated on 7/11/2024 से.
Yes, Lordship.
Learned counsel for the अच्छा appellant को कहते shall take instruction as to whether there is anybody in the family to take care of the appellant in the event he is released on bail, because ये जो mental condition कथा आपण ये तो copy of the report regarding health condition and conduct এটা कोन आसला copy टे आसला
से health condition good अछि. I am state that his conduct and behavior inside sub jail from his admission is satisfactory.
ଆମେ ଯୋଉ ମୁଣ୍ଡ ଫୁଣ୍ଡ ଖରାପ କଥା କିଛି ନାହିଁ
ସେମାନେ ଯୋଉ ସାଇକେଟ୍ରିକ୍ ଡକ୍ଟର ରିପୋର୍ଟ ଦେଇଛନ୍ତି। Yes. On the date of occurrence, he was
ଏଇ ଯୋଉ ଏଇ କାଳେ ଯାଇକି ବାହାରେ କଣ ପିଟିପାଟି ଦବ ନା କାହାକୁ କଣ କରିବ ସେଇଥିପାଇଁ କହିଥିଲା ରିପୋର୍ଟ ଦେଇଥିବ। Borderline intelligence and presently suffering psychosis NOS. His mood is depressed. No abnormality found in thought and perception. He does not have insight of his illness. He remains aloof, does not mix up with fellow inmates, does not participate in the festival. He gives vague rationality behind the act.
So he's remaining exclusive, secluded.
Psychosis NOS mean not otherwise specified.
ନାଇଁ କିଛି ବୋଧେ ଆଖି ଘରିଆ କହିଛନ୍ତି ଥିବେ ବୋଧେ ଯେ ଏ ମୁଣ୍ଡ ପାଗଳା ଲୋକ ଭଳିଆ ବୁଲୁଥିଲା ଏମିତି ସେମିତି ବୋଧେ କହିଥିବେ ନହେଲେ ସେ କୋଉଠୁ ଆଣିଲେ ସେ ସବମିଶନ ଯୋଉ କଲେ ଏଇ ଟ୍ରାଏଲ କୋର୍ଟ ରେକର୍ଡଟା ଦେଖି କାହାକୁ ମାରିଛି କାହାକୁ ବୋଲି ଆଲିଗେସନ ଅଛି
ଇନଫର୍ମାଣ୍ଟ ର
mother of the informant.
ମଦର ଅଫ
ସେ ତା ଇନଫର୍ମାଣ୍ଟ କହୁଥିଲା ତୁ କାହିଁକି ତୋ ମାକୁ ରଖି ଟ୍ରିଟମେଣ୍ଟ କରୁଛୁ ମୁଁ ତତେ ମାରିଦେବି।
ଗୋଟେ କାତି ଧରିକିନି ଇଏ କରୁଥିଲା।
Yes, my lord. PW 1 to 4 are eyewitness to the occurrence, and PW 10 and 13 they have witnessed the present petitioner holding a kati was running.
But no witness is there, Lordship. Present petitioner killed the deceased, Lordship.
PW 1 can have glass to PW 1.
ଏକ ନମ୍ବର ସାକ୍ଷୀ ଆସିଲେ କଣ କହୁଛନ୍ତି ଆଇ ୱିଟନେସ୍ ଅଛନ୍ତି। Suddenly, I and my children heard sound and we suspect that my mother fell down, for which I and my children rushed to the room and found that the accused was going out of the room while holding a kati and my mother was lying on the floor, sustaining severe bleeding injury and blood profusion, so and so. I chased the accused. So immediately after, so he's a witness to the part of the occurrence. Actual assault ଟା ଦେଖିନି ବଟ୍
ସେ ଘରୁ ବାହାରି ନଥିବା ବେଳେ ଦେଖିନି
ଗଲାବେଳେ ଯୋଉଠି ପଡିଛି ଡେଡ ବଡି ସେଇଠୁ ସେ ଯାଉଛି ଏବଂ କାତି ଧରିକି ଯାଉଛି ଏଇ ପାର୍ଟ ଟା ଦେଖିଛି ନା।
Prior to causing of incident, the accused used to say, "Why I kept my mother with me? He will kill her." For which I protested him by abusing him.
Accused are relation कौन PW1 रो
ସେ ତାର
cousin
brother।
It would not be safe actually. That's if this type of conduct is there. माने चुपचाप रहउछंती ये करछंती कासायन मिसुनांती एटी ट्रीटमेंट मध्ये चालीछि मेडिकेशन रे रहिछंती
मेडिकेशन
तो बाहर को गले तो कोन हबो नेडा की कहि परिबेनी।
रेगुलर ट्रीटमेंट सिंस 17/8/2021
पर यदि किसी ट्रीटमेंट रे अवहेला थांता मैटर तेणु
17/8/2021 the occurrence took place on 15/7/21 so it is
and even if जो केस रे नियंती जे mentally unsound थिला बा he does not know the consequence of the act ସେଥିରେ 84 को ये करिके नि एक्यूटल हेले मध्य ताकू छड़ा जाएनी कस्टोडी रे रखा जाए अंडर ऑब्जर्वेशन आउ ଦିଆଯାଏ ଯେ କିଏ ଯଦି ତାର ଲୋକ ଦାୟିତ୍ୱ ନବ ତାହେଲେ ଇଏ କରିବେ
Yes, Lordship, that extent I am file affidavit, Lordship.
କି
That is-
affidavit
Father would affidavit ଦେଇଛି Father is
Yes.
77
Lordship, that is marked as flag B, Lordship.
Father is 77
Flag B.
What is the date of custody?
Lordship, custody since 19/7/2021.
That is also Jane.
1907. Also in
All the treatment also is
So, put of this matter, Land Counsel for the state has produced the report from the Superintendent Subjail Chhatrapur, which shows that the petitioner is under psychiatric medication and his case is these cases of borderline intelligence and presently suffering from psychosis NOS, all capital. The report is taken on record. You have got that affidavit which has been filed.
Yes, ma'am.
Take instruction on that affidavit. We are keeping it after summer vacation. An affidavit has been filed by the father of the petitioner. That he is willing to take care of the appellant and keep him under proper medication as well as under his supervision. The Land Counsel for the state seeks some time to obtain instruction. अच्छा 18 कॉपी दी था 12 तारीख कर दी था शिफ्ट रिपोर्ट और आगे लंबा डेट है जो उनकी तो 12/5/2025. Next.
Item 13.
I think the 39 Lordship can be taken up next week, Lordship. Mr. Pal is not there.
Mention is made on behalf of Mr. Pal to take up this matter next week. This matter. We commencing from 21st of yes.
Item 14. Item 14.
Yes,
In item 14, I have not selected the paperwork.
Ms. Sunita Biswal and counsel appearing for the appellant submits that she has not received the copy of the paper book. Let a copy of the paper book be supplied by the registry to the Land Counsel for the appellant. You have received the
Yes, madam.
Land Counsel for the state submit that she has received the copy of the paper. Yes.
Item 15.
We roughly on 21st. Yes, Mr. Moon.
Lord, appellant has been convicted under section 302, 34, 449, 34, and 394, 34, and 120 BIGC.
You have got the deposition copies.
Madam.
The case of circumstantial evidence.
There are how many persons face trial?
4.
All of them have been found guilty.
Yes, Lord. Case 15 of the judgment.
But are three appeals, so why one is left out, or in one appeal there are two?
I am appealing in the last item. My appeal is yet to be admitted, my lords. That is CRLA number 385 of 2025.
Yeah, just a minute.
My lords.
সেটা বার করে লাগে CRL number 385 যেটা কিছু অর্ডার হয়নি না আচ্ছা স্টাম্প রিপোর্টিং কিছু দেখিনি ডিলে টিলে আচ্ছা এইটাও পর্যন্ত তাহলে 385 of 2025 hard admit call for the nine trial court record has already been received. The interim applications you don't want to move it today, Mr. Panda?
If your lordship is hearing this, I am there with my learned senior.
All right. Yes, Mr. Moon, please pass it.
Yeah. Page 35 of the judgment.
No, just one thing. All the four have been found guilty or what?
All the four.
One is not on appeal.
Huh?
One is not in appeal.
One
because,
who is
because
that?
all the appeals are individual.
Separately. Bengo file করছি criminal bill 1
विजय यादव फाइल करना है
हाँ
विजय यादव
अच्छा ठीक है so please come to paragraph number 2, Mr. Moon. The prosecution case is narrated there. Please ask your associate to read that and thereafter he will argue. Ask her to just read paragraph number 2. Yes. Paragraph number 2.
Judgment.
Paragraph number 2.
The facts then for discuss and appreciation of the case. The informant got telephoning information from her husband that her parents were found lying on the ground of their house with full of blood. Getting such information, she rushed to the spot house from her house, and her husband also came from his office to the spot. They found a huge crowd gathered here along with police in front of the building. She came to know that her father has been shifted by driver Gajendra and the other inmates of the mess to Ayush Hospital, and he is in a state of a coma. She also found her mother lying dead, and a computer cord found tied around her neck. All other rooms were unlocked. The keys, which were hanging from the neck of her mother, were found lying on the disturbed bed. The iron chest was found open. The Nokia mobile phone of her father having SIM number
Such and such,
and the Nokia mobile phone of her mother having SIM number such and such, along with one laptop, iPad.
Apple iPad.
All right. So now, Mr. Moon, please tell us that what are the circumstantial evidence in this case?
We are page 35, Your Honor.
35. This one.
Paragraph 14.
35, paragraph 14. Okay, that is summed up 36 actually. Page 36 para 40. Yes.
The confessional statements given by the accused person soon after their apprehension. This is confession before police. Theory of leading to discovery. Theory
theory of recovery of trial proceeds and booty soon after the incident. These three are against me, the other are not against
Chance
my
fingerprint मिलना?
Milord?
Chance fingerprint you
No, that is not mine.
That
Some
is
other
from,
agents.
that is from CHITTARANJAN copy.
And motive of plundering valuables of deceased persons, identification of robbed articles by witnesses in presence of magistrate. The article recovered from on my leading to discovery that has not been put to TI. Theory of handwriting of accused is not my handwriting, not some other accused. All details that is also not there in respect of the appellant. Theory of absconding, detection of human blood on the wearing apparels of the accused person, that is not mine. Conduct of accused persons before and after incident, finally homicidal death of deceased.
All detailed reports?
That is also not related to me, some other accused persons.
Absconding?
Absconding, occurrence on 14 FIR was lost. 19th, 18th night, that is 19th I was arrested.
The date of arrest now.
What is the
18/9/2012 night?
Yeah.
Okay. Conduct of the accused before and after the incident,
No, nothing, no such conduct is there.
So what have you led to discovery or what?
A laptop.
A stolen article.
Laptop.
There is no evidence that it was a stolen article. There is no, it has not been identified that in the TI period. Page 57, yes, the Planet Court has considered the evidence of the witnesses, PW 5 and 6. They are the witnesses. PWs 5 and 6 Miller, they are the two witnesses, independent witnesses. Page 55, it starts at para 24 there. What's you got it?
Para 25.
Para 24.
24. PW 5 and 6
are also the doctors.
Yeah.
They have not deposed in their official capacity in this case. Their testimonies never lead to any expert evidence, or they have not done anything in hospital or any other place like doctors. It is stated by both of them in corroboration that on the relevant night, that is 18/9/2012, at about 11:30 p.m. to 12 a.m., after taking dinner, they were returning from the hotel. Along the way, the car developed snacks, so they tried to get it started and run, but in vain. Since they found Sahidnagar police station is nearer to the place, they pushed the car to the police station so that car could be parked there. This is the explanation they have given how they came to the police station and became witnesses in this leading to discovery.
Okay.
This aspect.
No, about this laptop you are telling.
Yes, that
at your instance or
page 57
from your house or at your
no, that was recovered from a hostel where I was not the boarder.
What is that exhibit? What is the seizure list?
Seizure list is exhibit 12
of that laptop.
Miller.
Exhibit 12 that you have for it.
Image hostel, DHS Nagar.
Room of
Ujjwal Fandi.
Ujjwal Fandi. Image hostel.
Image hostel, BSS.
BSS Nagar, sorry, Nagar, from whom seized on being brought and handed over by and Ranjit Kumar Swanso. Acha, Ranjit means this present
appellant.
For Octo Sonoma. So I'm Swanso Chardin. Sankotaru Swanso, Loot Kori Swanso. Okay. ଏଇଟା ରିକଭରି ହେଲା ଆପଣଙ୍କର 19 ତାରିଖ ଦିନ ଘଟଣା ହେଇଛି 14
13 it maybe 13th evening or night. 14th morning.
ये
yes, sir.
लैपटॉप टाको केमती रिलेटेड କରୁଛନ୍ତି କୋ ରିଲେटेड
PW2.
नहीं
PW2
the submission is that except this one, that means leading to, let us say, leading to discovery or whatever it may be,
Yes.
of that laptop, which was seized as per seizure list exhibit 12. There is no other material against this man.
Priyaranjan Pati.
No, Ranjit Jana.
Ranjit Chandra.
So, are you disputing this submission which is made by the Mr.
No, my lord, I am not disputing. But at the instance of the present petitioner, Ranjit Jana, the laptop was recovered, and that laptop was identified.
ସେଇଟା ସେଟାକୁ ଛାଡ଼ି ଦିଅନ୍ତୁ ତା ଛଡା ଆଉ କିଛି ନାହିଁ
ନା ତା ଛଡା
ଠିକ ଅଛି ବର୍ତ୍ତମାନ ଲ୍ୟାପଟପ୍ କୁ ଆସନ୍ତୁ ଲ୍ୟାପଟପ୍ the as it appears that it was seized from the room of a
one hostel. At the
in occupation of one Ujjal Tandi.
At the instance of the
No, I was apprehended at Maharaja Sinha Hall.
Lead to the hostel.
From there, I was taken in custody to that hostel. What that was?
Unless the material comes that this laptop has got any connection with the two deceased persons.
Yes.
But from
the FIR, as well as in the statement of the PW2, it is mentioned that two mobile phone, laptop, and some ornament have been stolen.
Who are the, apart from the two deceased, their children are
staying apart.
No,
PW2 is the daughter.
PW2 है ला daughter, आउ किए?
Say PW2
अच्छा PW2 identify करची?
Yes.
Laptop तक?
Yes.
जे को basis रे पहला laptop से कर?
He know that it is the mobile phone of her
laptop कथा पासून PW2 evidence है तुम्हारा?
My lord. Page 10.
laptop टा कौन सुना गौना ना कौन? No, laptop टा basis करियो ना एटा हमें किना आइथिला ए document ए number या तार ये
that is not that but
then how can you अरे गोटे Apple आपण गोटे laptop देखै देबे से laptop टा मु कहबी एटा होची मोर so what is the basis
regularly व्यवहार होथले his father was usually using that laptop
सब हमरो समस्त को गोटे प्रकार laptop दिया हिच हला कंप्यूटर डिसीजन होजे तो एमती कंप्यूटर लैपटॉप टा थिबो हमें कहि देबो ये unless it is opened and we see that we are using it
but in this case my single laptop was using her father and he
सेति पई कहउची जे ताकू कोनोसी टेस्ट करिकिनी से लैपटॉप रु देखिचंती आपण जे this has got some relevancy with the deceased persons or any of the family members
no simply from the appearance of the laptop
and what has been done by the IOM?
How is that this matter was of 2012 and the trial has been taken after long time? The matter is of 2012.
Unfortunately, a lot of inadmissible evidence was laid, allowed by the prosecution to lead, and on that cross-examination has been done endless.
But the appellant was in judicial custody.
All through
8.5 years he was in custody.
During trial, thereafter he was granted bail.
During trial, he was granted bail by the Honorable Judge.
After remaining for 8.5 hours.
8.5.
Mr. What type of laptop you are using? Which laptop? HP. Office देइछि ना?
ना
personal. अच्छा मु आपन को एटी 10 टा लैपटॉप आनी HP रो सेही ब्रांड रो थोई दी बेटी हला आपण लैपटॉप ओपन न करी जानि देबे आपण कहि देबे कोटा आपण को लैपटॉप unless you आपन को ओम की कोन गोटे स्पेशल
the laptop that you have been using must have a specific mark by you by which you can identify not otherwise
the sticker uthi jai kothi
whatever
scratch
if you examine the laptop the contents will reveal that
contents is the best thing laptop रे contents असो contents ही कहि परिबो जे एटा आपन को लैपटॉप की नाही हां तेनु ସେଭଳି ଯଦି ଆପଣ କିଛି ଆଣି ନାହାନ୍ତି ତ ଟିଆଇ ପ୍ୟାରେଡ୍ ତ ହେଇନି ତ
ନା
ଖାଲି
ନା ଟିଆଇ ପିରିୟड ହେଇଛି ନା
କଣ
ହେଇଛି
ହଁ ଏଇ ସିଜ୍ ଆଇଟମ ର ଟିଆଇ ପିରିୟड ହେଲା
ଲାପଟପ୍ ର
ହଁ ୟେସ୍ ଲାପଟପ୍ ର ଟିଆଇ ପିରିୟड ହେଲା ଟିଆଇ ପିରିୟड ରେ PW2 ଆଇଡେଣ୍ଟିଫାଇ କଲା
No, no,
yes
you are
that is
mistaken.
right ନା ନା
let us see the TI
yes my
PRD
lord
report.
PW8 is the magistrate,
yes PW
Just a minute.
page 120.
PW8 evidence one.
property direction of reputation.
TI PRD report ଟା ଦେଖିଲେ ଜଣା ପଡିଯିବ।
PW8 paragraph 1 last sentence, Miller. The suspected properties were one imitation necklace and 7 number of imitation bangles.
Mr. Nayak,
my lord
ଦେଖନ୍ତୁ ଆପଣ ଲାପଟପ୍ କୋଉଠି PW8
my lord PW2 at the instance of police one TI period was conducted
କାଇଁ paragraph ଟା ପଢୁଛନ୍ତି ଆମକୁ କୁହନ୍ତୁ
paragraph my lord 3 of PW2
PW2 ଓହୋ
para 3
my lord
PW2 ସିନା କହୁଛି ଯେ କଣ
TI period
TI ପ୍ୟାରେଡ୍ କରିଛି ଯିଏ ଲୋକ ଆସୁଛନ୍ତି ତାଙ୍କ ପାଖକୁ ଆସନ୍ତୁ PW2 କହୁଛି ମୁଁ ଆଇଡେଣ୍ଟିଫାଇ କରି TI ପ୍ୟାରେଡ୍
yes
କୋଉ paragraph ଟା
paragraph 3
paragraph 3 let us see
at the instance of police one TI parade was conducted in respect of the seized ornaments laptop mobile phone in presence of judicial magistrate I had identified the aforesaid articles during TI period correctly
line ମୁଁ ପାଉନି paragraph 3 ରେ
1 2 3 4 5 6 7th line from the top my lord
at the instance of
yes sir.
Acha. Bartaman now Mr. Moon's submission is that no such TI parade has been conducted in respect of the laptop. And the only witness who conducted the TI parade and examined is PW8.
Yeah.
So देखो PW8 रे evidence रे जे the laptop टा trace ହେଇଛି କି ନାହିଁ କାରଣ TI parade magistrate prove କରୁଛନ୍ତି ତାଙ୍କ report को the report has been marked as exhibit 5 ଗୋଟେ report ଅଛି
5/1
ଏଠି magistrate କେବଳ ତାଙ୍କର
5/1 is the TI period report.
magistrate ତାଙ୍କ ରିପୋର୍ଟ କେବଳ ଦେଇଥିବ ନା
ରିପୋର୍ଟ ଟା ଖାଲି ଦେଇଛନ୍ତି ସେଥିରେ ସ୍ପେସିଫିକ ମାନେ କଣ ପୁଟ କରାହେଲା ସେଠି
ଆରେ କେମିତି ଆଉ TI ପ୍ୟାରେଡ୍ କଣ ରିପୋର୍ଟ କଣ
ଯାହା ସାକ୍ଷୀ ଦେଇଛନ୍ତି
ସାକ୍ଷୀ ନୁହେଁ ସେ TI ପ୍ୟାରେଡ୍ ରିପୋର୍ଟ ଟା
ରିପୋର୍ଟରେ ସେଟା ଜଣା
ହଁ
because it is the question of property she must have told no during parade
ତାଙ୍କର ସେ ଯାହା ଜଣା ପଡୁଛି ଏ ପ୍ରପର୍ଟି ଗୁଡାକର ଆଇଡେଣ୍ଟିଫିକେସନ ପ୍ୟାରେଡ୍ ତାଙ୍କର ଏଠି କରିଛନ୍ତି ସେ କୋର୍ଟ ରୁମ ର ଏ ଯୋଉ ତାଙ୍କ ଚାମ୍ବରରେ କରିଛନ୍ତି ଇଟ୍ସ ଅଲ୍ ରାଇଟ୍ ସେ ଚାମ୍ବରରେ କରିଛନ୍ତି କିନ୍ତୁ ଚାମ୍ବରରେ ଲାପଟପ୍ ଟା ପ୍ଲେସ୍ ହେଇଛି କି
TI period report ରୁ
exhibit have you not gone through the reports please take on this exhibit 5 ଟାକୁ ନିଅନ୍ତୁ ଆଉ ଗୋଟେ ରିପୋର୍ଟ ସେ ପ୍ରମାଣ କରୁଛନ୍ତି exhibit 21 ଗୋଟେ ରିପୋର୍ଟ these are the two reports 5 and 21 ଦେଖିଲେ 5 exhibit ବାହାର କରନ୍ତୁ exhibit 5 ଟାକୁ ଦେଖନ୍ତୁ ଆଉ 21 ଟାକୁ ଦେଖନ୍ତୁ
Suspect persons. 21 is of suspect persons.
ନାଇଁ exhibit 5 ଟା ହଉଛି
5/1 is property.
5 ରେ ଲେଖା ହେଇଛି ଗୋଟେ ଇମିଟେସନ ନେକଲେସ ଆଉ 7ଟା ହଉଛି ବ୍ୟାଙ୍ଗଲ୍ସ ଦେଖିଲେ 5 ଟା ବାହାର କରନ୍ତୁ লিস্ট অফ এক্সিবিটস টা মারবেন এই সেটা বসি এক্সিবিটস PW20 তଳେ ଅଛି লিস্ট অফ এক্সিবিটস ফাইভ দেখুন हाँ दीटा टीआई करेक्ट रिपोर्ट ହେଇଛି
ଗୋଟେ 5 and ଗୋଟେ 21
हाँ ଗୋଟେ ହଉଛି 5 ଆଉ ଗୋଟେ ହଉଛି 21 5 ଟା ହଉଛି पेज नंबर ଏ ଯୋଉ 620 ରେ ଅଛି
ରାଇଟ୍
1251 टा हूँ पेपर बुक नंबर तार 650 पेज 620 पेज रे अच्छी एग्जिबिट 5 620 पेज ऊपर
necklace of Bengal.
पेज 620 620 पाई गले बर्तमान देखो कॉलम नंबर 3 को आसो कॉलम नंबर 1 इमिटेशन नेकलेस आउ 7टा नंबर ये गला ये गोटा रिपोर्ट गला बाकी नेक्स्ट रिपोर्ट होची एग्जिबिट 21 21 को पड़े आसो एग्जिबिट 21 होची एट पेज 642 को पड़े आसो एटा होची आइडेंटिफिकेशन ऑफ पर्सन एंड दी जन लोक जनक ना होची नहीं सॉरी से होची विटनेस मानक ना पटले तापर सस्पेक्ट सेटी प्लेस हेले identifying witness could not identify any of the suspects. So this is relates to suspect. Person. So person property देखिले property रे laptop नहीं. तो TI parrot कोठी हला.
P2 question.
अरे
yes मेरे
पता. कि जहाँ कोई वो कौनो ये.
And after seizure, it was given in her Jima. Then she produced it in court at the time of evidence. So even if she had identified, what value that identification evidence would be?
ये जो जिम मारे दिया ला बोले किए कहउचंदी
से निजे कहउचंदी PW2
PW2
The paragraph 3, paragraph 3 of our evidence, about 5-7 lines from the beginning, on 16/1/2013, police had left the seized imitation ornament of my mother, such as so-and-so, laptop belonging to my father, to so-and-so in my Jima.
laptop भी अच्छी 16 तारीख में
16/1/2013 रे ताको जिमारे देइथिले से ताकू कोर्ट रे प्रोड्यूस करले 24/8/13 रे
टीआई पैरेट मजिस्ट्रेट केबे करले जो टीआई पैरेट 2004-10/2012
thereafter 16/1
8-10/2012 रे कले जो सस्पेक्ट मानकर टीआई पैरेट आउ 4-10 रे करचंदी जो बैंगल्स आउ नेकलेस का प्रॉपर्टी say Mr.
My lord, that is there, my lord. PW2 has stated that she identified the TI period, but I am not getting the TI period.
टीआई पैरेट तो एविडेंस देखिले आ जो दीटा जाको मार्क हेची टीआई पैरेट रिपोर्ट ताकू मध्ये आपण देखिले गोटे होची एग्जिबिट 5 आउट होची एग्जिबिट 21 एग्जिबिट 5 रिलेट्स टू द टीआई पैरेट of the property and
जिम्मा नामा एग्जिबिट 4 कौन जिम्मा देले
कोडा
से कहउछन on 16/1/2023
नहीं सी तो कहउची मु जी मते 16 एकरे देई देले पुलिस जबत हला एग्जिबिट 2 रे आपण एग्जिबिट जबत लिस्टा केते एग्जिबिट 12 एग्जिबिट 12 टा देखो आपण
19/9/2012.
Exhibit 12 ହେଲା 19/9/2012 ହେଲା ତ ତାର ପ୍ରାୟ 3 ମାସ 4 ମାସ ପରେ ତାକୁ ଦେଇ ଦେଇଛନ୍ତି ଟିଆଇ ପ୍ୟାରେଡ୍ ହବାର କିଛି ଏଭିଡେନ୍ସ ହିଁ ନାହିଁ ତେଣୁ ଲାପଟପ୍ ଟା ଗୋଟେ ହଷ୍ଟେଲରୁ ଜବତ ହେଇଛି ଆଟ୍ ଦି ଇନଷ୍ଟାନ୍ସ ଅଫ ଏଭିଡେନ୍ସ ଆକ୍ସେପ୍ଟ କରାଯାଏ ଲିଙ୍କ ଆସୁନି ଯୋଉ ଚୋରି ହେଇଛି ବୋଲି ଏଇ ପର୍ଟିକୁଲାର ଲାପଟପ୍ ଟା unless you ଏତିକି ଯଦି evidence ଆସିଲା was on bail after 8.5 years he has been granted bail by the
case of double murder, my lord, and two senior citizens, my lord.
double murder ହଉ କି ଚାରିଟା
Only,
murder
my
ହଉ
lord, my
ଆପଣ
submission
କୋଉ
is,
evidence adduce କରିବେ କିଛି ତ ରହିବ ନା ଏମିତି
my lord, my submission is,
It was 494.
in this case, my lord, the paperwork has not been supplied to me. Therefore, I am unable to assist your lordship properly, my lord. Only to some copy of the copies of the deposition. But where from I will get the exhibit and other thing? If your lordship will grant me.
we are not in a hurry if you want it can be taken up
Yes,
next week
paperwork
on
with the
15
paperwork.
16 paperwork is you have not received the paperwork
My lord.
so you receive the paperwork
My lord.
and also the exhibit list if you want you can take it in your pen drive also
My lord.
Lekon CRL number 218 of 2015 are Mr. S.K. Moonland senior advocate Mr. Parthasarathi Naik learned additional government advocate after arguing for some time submitted that he has not received the copy of the paperwork. Paperwork किए फाइल करते
paperwork तो है ही नहीं.
Paperwork तो है नहीं.
I will take some pen drive.
He has not. Though he has received the deposition copies, but he wants to take the exhibits, list of exhibits for them, exhibited documents in his pen drive. Let the registry supply the exhibited document to the learned counsel for the state in his pen drive. Mr. Mood, you are having those documents with you. All right. Put up this matter on 16th. You are available? Yes. 16th April 2025 with CRL number 251 of 2025 and CRL number 385 of 2025.
But I have a small player, my lords. May I be permitted to take those same LCR on my pen drive?
No. You can take the deposition copies you are not having and also the exhibited documents you can also take it. अच्छा इधर जो देवाशीष पन्नाकर जो matter है the learned counsel for the appellant submitted that he may be supplied with the deposition copies and so on so जो exhibited document trial court record तो पड़े अच्छे ना तो registry will supply the so on so to this ना in his pen drive से डॉक्यूमेंट गुड़ाक जदि नबा कथा आजिका जरियार नहीं जातु माने फाइल पड़े होला
आज्ञा
आ किछ नै तो श्योर